Thank you. Good morning, everybody. It's April 15, 2026, and welcome to the Appeals Court. We're in the Hale Courtroom, Courtroom 4. I think there's another session going on across the way. But if you've checked in with the court officer, hopefully you're in the right place. So, good morning. Your panel today is me. I'm Greg Massing. To my right is Justice Ditkoff. To my left is Justice Hand. For those of you who might not know the rules, it's 15 minutes per side, no rebuttal. So, and we have read all the materials. One other thing, at 13 and a half minutes, the yellow light goes on, meaning you have a minute and a half left. And when the time is up, it turns red, and then it counts up. So people look sometimes and think that they have more time, but actually you have less time. We have read all the materials, so you can start right into it. Like I said, you have 15 minutes. You're free to use it all, but there's no penalty for stopping early. And I believe this morning we've taken the little bit out of order. We're hearing the third case first. So calling 25P1285 Commonwealth versus MOJICA.
Morning, Your Honor, and may it please the Court, ADA Sean Buxton for the Commonwealth, asking that you reverse the order allowing the defendant's motion to suppress. The affidavit in this case established probable cause of three things. It established probable cause that the defendant was running an ongoing drug distribution operation. It established probable cause that she kept a ready supply of drugs in the car as part of that drug distribution operation, and therefore it established probable cause to believe that evidence of a crime would be found in the car on the date of the issuance.
All right, well, that second one was a big jump, so why don't you defend it?
And Your Honor, I'll provide the facts that allow for that reasonable inference, which is that on the date of the second controlled buy, which was on or around May 5th, approximately 23 days before the issuance of the search warrant, the confidential reliable informant made arrangements with the defendant to make a purchase of narcotics, of cocaine, as the CRI had been doing. However, in this case, unlike in the other two controlled buys, the defendant was not home. And so the defendant arrives back at her home in her vehicle. The affidavit is very clear that the defendant then stays in her vehicle, does not leave. The CRI approaches the door, the driver's side window goes down, the hand-to-hand transaction occurs, the CRI returns to the police with drugs.
So there's the CI is looking in, but there's nothing in the affidavit that says he saw where she got them from, she got them from the glove compartment, she got them from the console. How do we know that she didn't have them in her purse or that it wasn't on her person?
I don't know if we necessarily need to exclude the possibility that drugs could be on her person as well. I think, as in Escalera, the fact that evidence of the crime might be somewhere else does not necessarily exclude the possibility that it might also be kept in the car. Obviously, this is a CRI. This is not a trained law enforcement operative, so they're maybe not trained to look at the various places in the car where things are stored. And I would also note that when it comes to controlled buys from houses, the same level of detail and specificity is not generally required. In this case, the CRI goes to the back door of the house, the back window goes up, drugs come out, but the CRI doesn't go into detail about whether it comes from the cabinet, whether it comes from a purse, whether it comes from the defendant. So I would argue that where the level of specificity is not needed for something like a house, which is entitled to greater constitutional protection, then that level of specificity is not needed for a car either.
Is there another case in which the connection between the car and the drugs, or the car as a location where drugs might be stored, is as limited as this one? This isn't a drug delivery business allegation, it's a drug distribution.
Your Honor, I would argue that there's no case, obviously, exactly on point. I think the closest case would be Santiago, where there was only one controlled buy in which the drugs were retrieved from the car. I think this is similar to Santiago in that there was one.
You said that was a close case, right? Santiago was one that was close to begin with, and this is even closer. Would you agree?
I would agree that Santiago was a close case. I think the case says it. I don't think I can disagree with that. I would also agree that this case is a close one.
I mean, in Santiago, doesn't the defendant go over to the car, essentially get something out of the car, and bring it back?
Yes, yes, and I guess I would just note that I don't think that makes a difference for constitutional purposes here. As you mentioned, Santiago could have kept a bag in the car that he could have been retrieving it from. It could have still been in some way on his person, but I think here, I would also note the distinction between Wade. I know Santiago referenced Wade. I think Wade is sort of the elephant in the room as to this whole case, as the judge below noted. And I would note that in the Wade case, the affiant seems to have averred themselves into a corner. They averred very specifically that the car in that case was used for distribution and the house was used for storage. We don't have that here. We have evidence that a controlled buy was conducted and that controlled buy was able to be done without any returning to the home. Perhaps if there was more facts here that suggested that the defendant was returning from a drug deal at the time that she returned to the home, but what I would note is that this was essentially a random time for a controlled purchase selected by the CRI and by the police. And the fact that the defendant at that random time selected for the controlled purchase was able to return home and present the narcotics from the car suggests that at the time of the search warrant, the same outcome would occur, that they go to search the car. It's a time that maybe the defendant isn't expecting. It's not that they're immediately coming from a drug dealer, immediately going to one. There still is that expectation that drugs would be there because the last time there were. And I would also just note.
What about the time gap? The affidavit says on or about, or it actually says the week of May 5th, but we're assuming that it was May 5th for you're not challenging that. The judge said.
No,
okay.
Not at all, Your Honor.
23 days.
So it's been 23 days. I think, in my view, the Cologne and Cruz cases sort of address that concern and suggest that it shouldn't be a concern. Where the defendant was engaged in an ongoing drug distribution business, I don't think that can really be disputed here, where there's three.
Are those car cases or residence cases?
Those are residence cases. There's a sort of a dearth of car cases in the case law that I could find. However, in the house cases, it does suggest that timeliness becomes less of a concern where there is evidence that the drug business is ongoing. Here we have the CRI's prior information that this was a drug business when the investigation started. We have an immediate observation by Officer Aguirre as to a sort of uncontrolled purchase of narcotics, and then we have the three controlled purchases which occur over the course of a month and within the 48 hours. So I would suggest there's more than enough here to suggest that the defendant was engaged in ongoing drug business, and where that happens, I think timeliness becomes less of a concern. I would also note that any staleness concerns would be ameliorated by the fact that there was this controlled buy within 48 hours. So I would say that the Cologne and the Cruz cases suggest that timeliness shouldn't have been a concern, and as I mentioned previously, the fact that this 23 days ago there was a purchase on a random day in the week of May 5th, and the defendant happened to have narcotics in her car on that date suggests that the same would be true 23 days later in light of the.
Let's discuss the other problem, which is what authorizes the police to search the car at all?
Well, Your Honor, we do have a valid search warrant here. I would.
Right, but what in that warrant allows them to search the car?
Search at the car for the car. I don't dispute with the.
I mean, they get to search. They found the car. They even get to seize it, but what gets them the gun inside the car?
I would suggest that in that case, it is the affidavit which was attached with, at least as far as we know, we obviously don't have an evidentiary record of that because this was a non-evidentiary four corners hearing in this case. But the affidavit does state that it is requesting to search for crack cocaine, paraphernalia, money, bank books.
I mean, the case law says that the search warrant affidavit, if present, can inform what the police are searching for. But is there any case that says it can inform what they search?
Well, I guess my reading of the warrant is that it's almost a little too clear on what they search and not clear enough on what they search for. I mean, the car is written twice as to be as what they're searching.
What they're searching for, not what they're searching.
I would
The search for the following property: 2008 black Acura MDX, and they did a great job of finding it.
Yes, I mean, the affidavit goes on to state that they wish to utilize keys found in the car, wish to search food containers, toolboxes, or any other places where the above items may be hidden. So it does suggest that both in the house and in the car there is going to be a deeper search of the contents, and that the hope, obviously, in the affidavit is that those contents would bring evidence of crack cocaine, paraphernalia, et cetera. So I would argue that.
But you haven't found, I haven't found a case that says the opposite. You haven't found a case that says you can use the affidavit to clarify what should be searched. I mean, I haven't seen one that says it doesn't either, but you don't have one either way.
I don't believe I have a case as to curing that particular deficiency in a warrant, no, Your Honor.
You seem to also suggest in your brief that this is waived or not really raised below, but I mean, doesn't, like, the four corners here of the affidavit are, and the defendant does raise in the motion, the affidavit lacks, I mean, the warrant lacks particularity. Doesn't that sort of shift the burden to the Commonwealth to prove that it was attached?
I would argue that a little more is required to shift the burden to the Commonwealth. If the defendant had averred something to the effect of, I was present when the warrant was executed and the affidavit was not attached to the warrant.
But why is the defendant says this warrant doesn't say what to search for? Isn't that why is it her burden to say and it wasn't attached? I mean, well,
at the time of the filing of the motion under Rule 13, it's the defendant's burden to present sufficient facts to warrant a hearing, and I argue that where we have a very clear affidavit and a warrant that states that it incorporates the affidavit by reference, we have a statement from the trial prosecutor that it was attached. I don't think there was any real need to hold a hearing on this where the only evidence that's been presented at this point suggests that the affidavit was attached and that therefore the deficiency in particularity was cured. However, I would also note that if the court is not inclined to agree with that, I still think that there's an insufficient evidentiary record here to affirm on that basis. As you're sort of noting, the question here is whether the defendant was entitled to an evidentiary hearing. If this court concludes that the defendant did meet that initial burden of production and that the burden then shifted to the Commonwealth, then the appropriate remedy in that case would be to remand for an evidentiary hearing at which the officers who executed the search warrant could testify as to whether the affidavit was attached.
Was the other warrant, the house warrant, introduced at the hearing or given to the judge?
I believe it was, Your Honor. I don't want to state too firmly, but I believe it was.
If it was, I'd like to see it.
Okay. I would be happy to supplement, Your Honor.
And was there anything found as any instrument or any drugs found or any contraband found in the house? I
believe there was contraband in the form of narcotics found in the house. I'm not entirely clear on that, but and just to Justice Ditkoff's question, I did just want to note that the record is clear that the affidavits as to both warrants are the same, but I would be happy to provide the actual face of the warrant itself.
I just noticed mentions about how that warrant was very specific. And of course, they had both at the same time, so it might inform what a reasonable officer would think at the time, but only if the judge was offered. I mean, the judge didn't see it.
Absolutely, Your Honor. I believe the motion, there was, I don't want to misspeak, so I'll wait and I'll supplement. There are no further questions.
And if you just, obviously, if you determine it wasn't given to the judge, let us know.
Absolutely, Your Honor. Okay. Thank you.
Thank you, Attorney Buxton.
Good morning. Michelle Dame for Ms. Mojica. May it please the court. I am asking that you affirm the judge's decision allowing Ms. Mojica's motion to suppress the search warrant for her vehicle. The motion was properly allowed because the affidavit did not provide a nexus between the motor vehicle and evidence of criminal activity. It is well established that there must be probable cause that what the police are searching for here, drugs, would be found in the location that they were asking to search for, which was the vehicle. And there are several cases which detail what is and isn't a sufficient nexus when dealing with a motor vehicle. And one is Commonwealth versus Wade. And in that affidavit, there were 2 controlled purchases where the defendant arrived to the deals in their motor vehicle. And the appeals court was unpersuaded that those drug sales, coupled with the use of his vehicle to drive to the sales, was enough without more to establish probable cause. There was nothing which suggested that the vehicle was used to store drugs or that the defendant routinely carried an inventory of drugs ready for delivery.
What do you do with the fact that the CI calls her and she's not home, but she happens to have drugs on her in the car?
Again, there's not established where she may have gone after speaking with the informant. Her car was not under 24-hour surveillance, so we don't know if she made any stops before coming home. And again, the affidavit does not state where the drugs came from, if they came from the center console of the glove compartment, and does not state whether the informant saw any additional contraband inside of the car. And I know the Commonwealth relied quite a bit on Commonwealth versus Santiago, but I think it's important to note the difference in that case where after the defendant meets with the informant outside of the vehicle, returns to the motor vehicle to retrieve the drugs, and then goes back and gives the drugs to the informant, which suggests that that is where the drugs were being stored, and we did not have that in this case. There's also Commonwealth versus Staines, which involved 6 controlled buys that were all done with the defendant's vehicle. And during one of the buys, the defendant was asked for additional cocaine, and he was able to provide that cocaine, which allowed for the inference that he kept additional drugs in his vehicle at the time that he was making a sale. And that case involved an anticipatory warrant. So it wasn't saying that probable cause existed at any time to search this vehicle, but rather that probable cause only existed at the time that another purchase, that another undercover sale was planned, because again, the logical inference was that the defendant kept additional drugs in his vehicle at the time that he was making a sale. In Commonwealth versus Connolly, there was information that the defendant kept drugs underneath the dashboard and in the center console. And in Commonwealth versus DeFrancesco, the defendant took efforts to conceal his connection to the vehicle, which suggested that the cars were being used to store as well as transport drugs. And I would suggest that the nexus in this case is even weaker than the nexus in Wade, where probable cause was not found. There was one buy that took place while she was seated in her vehicle, and that was 23 days before the search warrant was issued. Again, the affidavit did not say that the drugs were retrieved from a location within the vehicle. The affidavit did not say that the informant saw additional drugs in the vehicle. And again, the affidavit did not say where she was or where she may have stopped prior to coming home. So there was nothing to suggest that she used her vehicle to store drugs or that she routinely carried drugs outside of the home ready for delivery. The detective did not form the opinion that she was using her vehicle to store drugs, and the information was actually that the usual practice was that the informant would go to the house, go up the stairs, and get drugs through the window. And Ms. Moika was not looking to hide her connection from this vehicle, and the detective was able to confirm that the vehicle was registered in her name. And in all cases where a nexus has been found between drug activity and a motor vehicle, there has been more than arriving on a single occasion where drugs are sold in the car. Now, the Commonwealth suggested in its brief that the judge ignored controlled buys 1 and 3 when allowing the motion, but those buys did not do anything to add a nexus to the vehicle. They provided the nexus to the house and corroborated the information that the police had up until that point. The investigation showed that she was storing and dealing drugs outside of her home.
What do you say to the Commonwealth's argument that based on the purchase of the drugs from the car, the police had probable cause to search the car at the time that the controlled buy took place, and therefore they should also have probable cause to search later?
Well, the question isn't whether probable cause existed to search at the time of the controlled buy, but whether probable cause existed to search 23 days later when the search warrant was issued and executed. And that kind of goes back to the Staines case where it was an anticipatory warrant and saying you're only allowed to execute this warrant once you know that the defendant is on their way to make a drug deal, which we didn't have in this case. There's not a blanket finding of probable cause just because at one date in time there was. The informant told police that they routinely had been buying drugs from Ms. Moika. The practice was to go to her house, go to the back of the home, go up the stairs, and they would get the drugs through the window. And when the detective did his own surveillance, he saw a drug-dependent looking individual arrive, go to the back of the home, return very shortly after with their fist clenched, suggesting that they had just purchased drugs. And then again, we have controlled buys 1 and 3 that corroborates that this is the routine practice of her drug delivery operation. And again, there could be times, we're not suggesting that just because there was probable cause to search the house means that there wasn't probable cause to search the car. There could certainly be times when there's probable cause to search multiple places. But here, the affidavit only supported a nexus between the drug dealing activity in the house and not with the vehicle. And the Commonwealth suggests that allowing this motion affords more protection to cars than to houses, but that's not true. The probable cause standard is the same. The nexus requirement is still the same. And the facts which supported the affidavit and which were established by the investigation, again, only provided that nexus to the house and not to the car.
I just ask, you did not challenge, or you're not challenging the search of the house?
No.
Okay.
I think a nexus was clearly established to be able to search the house. This is
And
just
apparently there's no particularity problem with the house search either.
It was not. It was just with the car.
Counselor, it seems to me that if we determine there was probable cause, that all the other problems kind of need to be hashed out at an evidentiary hearing. We have to figure out whether the affidavit was attached, even if we didn't have the warrant, there'd still be an automobile search, would at least be in the mix with testimony. Am I wrong on that?
Yes, I think the other issues could be established at an evidentiary hearing, and I think the affidavit, the motion, the affidavit, and the memorandum, which was all filed at the same time, put the Commonwealth on notice that the particularity of the warrant was being challenged. The affidavit said that the search warrant was not particular enough, and the memorandum cited the Padilla case, which talks about how it then is the Commonwealth's burden to establish that the affidavit was either incorporated or somehow otherwise present at the search at the time that the search warrant was executed.
Which case was that it cited?
What's that?
Which case did the motion cite? You said?
Commonwealth versus Padilla?
Padilla?
The Mass Appeals Court one, right?
Yes. And that case made it clear that it's a Commonwealth's burden to establish that the affidavit was either attached to the warrant or otherwise present at the time that the warrant was executed, that it is not enough to show that the pre-printed search warrant form states that the affidavit is incorporated by reference, that the affidavit itself must either state that a copy of the affidavit was attached to the warrant, or that police would have a copy of the affidavit present at the search, or the Commonwealth must present such information to the motion judge. And the Commonwealth simply stated during the hearing that the affidavit was attached to the search warrant without really providing any sort of evidence to support that assertion, which I would suggest would not be enough to meet its burden. And I think more evidence would have needed to be provided to the motion judge in order for the Commonwealth to meet its burden. If there are no further questions, I will rest on my brief.
Thank you both.
you.
Thank you very much. Thanks for being able to make it today.
Thank you.
And go get some rest.
Thank you.
Case is submitted. So, next case on for today, which was number 1 before, sorry about that, 25P257 Commonwealth versus DRAVON Robinson. How did I do with the first name?
All I can say, Your Honor, is that if you mispronounce it, I've been mispronouncing it.
Okay.
Good morning, Philip Weber, representing Mr. DRAVON Robinson. Mr. Robinson's case is here today as what I personally at least found to be a somewhat interesting circumstance, but nonetheless one in which the motion for required finding should have been granted. This kind of arose out of what I would say is an erroneous jury instruction to include the involuntary manslaughter, one that trial counsel did argue against and argued was an improper instruction. And
Do you maintain that argument in your brief? I'm not sure if you do. Are you arguing sufficiency in the brief?
Well, essentially, I'm arguing sufficiency. I refer to the fact that trial counsel was against the jury instruction because if they weren't, then it would be, I think, more problematic. And while I think the jury instruction is erroneous, ultimately, sufficiency is the issue now because we couldn't exactly go back and retry Mr. Robinson on involuntary manslaughter again because, again, we have a sufficiency issue in regards to involuntary manslaughter, and he was acquitted of, first-degree murder, so we certainly couldn't go back and try him on that.
Counselor, while we're there, and I don't expect you to be able to answer this, but just in case you can, I did some research, and I found 4 cases on this where a lesser included was found not to need to be given: Nardone, Ortiz, Thayer, and Rodriguez. And they all come up with different remedies. 4 different remedies in 4 different cases. If you're not familiar with the cases, that's totally fine, but if you do have some familiarity with any of them, I'd love to talk to you about them.
Unfortunately, Your Honor, I'm not familiar with the remedies from those cases, so I wouldn't be able to comment on them. But in this one, as stated, I at least as I'm arguing, the appropriate remedy, I think, is in terms of that the motion required finding would be granted, because it's a sufficiency issue that even if there was an attempt to retry him, because this is an issue where it's not about the specific facts. I mean, the facts at least not being contested in that regard.
And you agree there was sufficient evidence of murder?
The jury could have returned that verdict. I agree that the jury had the option, legally speaking, to return the verdict. But ultimately, since they didn't, they did acquit him, and thus I would argue that double jeopardy would apply in regards to that situation. But yes, legally they could have had that option. But ultimately they didn't. And that's really one of the things that is at issue here, because for him to have been found guilty of involuntary manslaughter, the jury was instructed in terms of the wanton and reckless conduct. Now, certainly their evidence could have shown that Mr. Robinson was kicking the victim, but the kicking did not cause or even really contribute to the death, and that's not a contested fact at all. In fact, the Commonwealth, even in their closing, talks about how the kicking is not what caused his death. The thing that caused his death was being stabbed multiple times, which is not exactly a surprising finding in that regard.
Are you arguing that he could only be found guilty of a joint venture for first-degree murder? I mean, because there are cases, and the one that Cunningham, where the defendant is convicted of manslaughter as a joint venture, but the principal is convicted of first-degree murder.
I would argue that in this situation, yes, that for him to be convicted of the first-degree murder, especially since he did not have any direct action that caused the murder, so he couldn't really be convicted of first-degree murder as direct action, so it would have had to have been a joint venture in that regard. And in this situation, I apologize, Your Honor, that I'm not familiar with the facts of that specific case, but in this one, I think the problem is that for joint venture, there does need to be at least that shared mindset in regards to this, and that is lacking here. This is not a situation in which it's an assault that somehow got out of hand. I mean, it's not just that he was stabbed once. He was stabbed multiple times by multiple people.
I'm sorry to interrupt you, but is there definitive evidence that would show when, relative to the kicking, the stabbing took place? Knives were made evident?
It seemed to be happening at about the same time. I mean, I don't know down to the second, but these were at the same moments that the kickings.
Based on the video or based on some other evidence?
The video, Your Honor, from my understanding of things. The video kind of shows the kicking and stabbing to be happening at the same time.
Why couldn't the jury find this was an assault that got out of hand? I mean, they come, they attack, and then the victim gets stabbed. Why can't the jury find exactly that?
I think when you're looking at a situation in which, if we were talking about a situation where there was one stab, maybe that could be something, but I think we're looking at a situation in which multiple people are stabbing this man multiple times. I just don't see how in any scenario that, even looking at the evidence in the light most favorable to the Commonwealth, I just don't see how multiple stabs from multiple people could amount to simply an assault that somehow went a little far. I mean, I think that is a level of force.
Well, why couldn't the jury find that it started as a non-knife attack and then the defendant disengaged when the knives came out? Or at least find the Commonwealth hadn't proved that didn't happen?
No, certainly. Well, in this one, as the evidence is presented, it really just shows that they're driving by, they stop the car, these individuals get out of the car, and just immediately start stabbing this man. I mean, this is not something where there was a fight and suddenly someone pulls out a knife.
Why do you say that? I watched the videos, and certainly there's quite a bit of stuff that happens after they come out of view. And, at least 5-10 seconds.
In my view of the evidence, Your Honor, because obviously I watched the video as well, everything I think happened in such a short period of time that I think that something in that short of period of time, I would find it difficult, actually, well, more than difficult, obviously, that unreasonable that it would be this idea of a fight escalating into a stabbing within, a few seconds is not the actions of someone or people, because there are multiple people in regards to this, and I do think the multiple people is significant as well. It's not the actions of people who are just like, oh, we were going to start a fight, and it happened to turn into knives. There's even talk about how they had the knives as they're, getting out of the car. Talking about Mr. Robinson knew about the knives beforehand, and in fact, knowing about the knives beforehand, which was part of the evidence as well, I think, is also significant, because there'd be an element if he thought that it was going to be, just something more minor. If he thought they were just going to, go and punch the guy, maybe that would change the situation. But this is evidence showed that he knew they had knives. They're stopping this guy within seconds.
Right, so what was the evidence that he knew they had knives before they stabbed the guy?
And I apologize, I don't have the exact line, but I do recall, and I certainly reference it in my brief, that it is talked about his knowledge, and certainly the Commonwealth argued it as well, that he had knowledge of the knives beforehand. So this is, I would say, not something that, and while watching a video, 5 seconds might feel longer, but in that moment, I mean, 5 seconds is quite short. 5 to 10 seconds, I would say, is quite a short period of time. I would argue that the evidence, as presented, does not show people who were trying to engage in a fight that just kind of got out of hand. These look like people who are, they see someone, they get out of the car, and they start stabbing him many, many times.
Wasn't the defense at trial that your client wanted to have nothing to do with it?
That is what trial counsel pursued in regards
And
to
so, and now your brief, now you're saying that actually he had to have been aware, he had to have wanted to have something to do with it. I mean, why couldn't the jury, somewhat credit the argument that was being made to them, say, well, he's not entirely innocent, but he was wanton and reckless with what he did?
I mean, obviously, I understand trial counsel's purpose in pursuing that strategy as a strategic defense. It certainly makes sense, but I think that the evidence in regards to this, and maybe that's a tricky situation, because most of the time when we talk about the light most favorable to the Commonwealth, we're talking about all the inferences that would certainly go in the other direction. And now it's kind of this odd situation in which the light most favorable evidence is somehow that he's less culpable than he would have been otherwise.
Well, we say light most favorable to the Commonwealth, but we mean light most favorable to the verdict, right?
I essentially, I refer to the light most favorable to the Commonwealth since, as Your Honor is quite aware, that's the Lattimore language in regards to it. So the language isn't the light most favorable to the verdict. It's certainly the light most favorable to the Commonwealth in that regard, and that's why we are presented in what is certainly a somewhat tricky situation, because
could any rational trier of fact have found the defendant guilty beyond reasonable doubt of involuntary manslaughter?
And certainly my argument is that no, given these circumstances, I don't think it just doesn't fit in terms of the logic of everything that goes together. You would have to kind of piecemeal together different things. It would have to be credit one set of facts, then not credit another set of facts. We kind of turn the light into the light.
Aren't juries allowed to do exactly that? They're allowed to credit part of what a witness says and not all of what a witness says?
I would argue that in regards to this one, it would be such a inconsistent level of crediting things that we would reach a point of it being where we're at in the current situation, because they're just things that, it's one thing to give different weights to things, but I think there at least needs to be some more logical kind of meshing of the facts together. I think there needs to be at least a level that the facts would fit together in order to produce a sufficient verdict in regards to this. Because, for instance, one of the things that the Commonwealth argues that I think doesn't really make sense is this idea that Mr. Robinson was kind of the getaway driver, when really the entirety of the evidence is just that he was driving a car, a getaway driver, because he got out of the car. He's not sitting in the car, with the car on, ready to go so that he could drive off. He gets out of the car with them. He gets back into the car with them. They're all doing everything at the same time. I mean, that's not really what someone has to drive the car. Obviously, it doesn't drive itself, at least not yet. So we're at a point where it's for him to be the getaway driver when they're all piling out and all piling back in, you know, because that's one of the things that the Commonwealth certainly is arguing that, oh, he was acting as this getaway driver. No, he was part of this group that was going and participating in this action. And even if the idea was as the getaway driver, even then we would still kind of encounter, because that would have to be under this idea of, you know, joint venture. And then we still encounter the same issue that we've been encountering, that the mindset, the intention here, because the intention of a bunch of people who get out of a car, go up to someone and start stabbing them numerous times. That's not a bunch of people who are like, oh, well, maybe we'll beat him up a little bit and oops, he happened to die. It's, you're stabbing people multiple times, and it's not as though it's like a stab in the hands or the foot. If we had been stabbed there and it had been a unique medical circumstance, maybe then, but that's not what's happening. I mean, he's being stabbed in very vital areas. It's not a surprising thing that he unfortunately passed away. It was very much the pretty much only real conclusion. I mean, I'm not a medical expert, so I guess I can't say only conclusion, but it's certainly from the evidence that was presented, it seems as though there was wasn't kind of a borderline, is he gonna make it or not? It was one of these things where he was stabbed in such a way that his death was just about all but assured. And that's the kind of actions of people who, if they had been found guilty of first-degree murder, that would have been one thing, because these are actions that I think very much show a very intentional use of force that was intended to try and kill somebody, not something that would fit under involuntary manslaughter. So unless there are further questions from the panel, I would rest on my brief.
Seeing none, thank you. Attorney Paris, here you are again, in front of us again, 1 week later. This is closer, I take it.
Yes, it is. Thank you.
We pride ourselves on a repeat business.
Yes, indeed. Good morning. May it please the court. Molly Paris on behalf of the Commonwealth, asking this court to affirm the defendant's conviction. I'd like to acknowledge the trial prosecutor with me today, Nathan McGregor. Starting with the sufficiency issue, there was clearly sufficient evidence here that the defendant engaged in wanton or reckless conduct under a joint venture theory, where after driving his co-venturers to the scene, he engages in this concerted attack. In the light most favorable to the Commonwealth, he's seen on the video kicking the victim, afterwards getting back into the car and facilitating his escape from the scene. Under the law of joint venture, this is clearly more than mere participation. And as to the intent, the only intent requirement was the intent to engage in that wanton or reckless conduct, not the specific intent to kill.
I mean, if he had been convicted of first-degree murder, I think we could find the evidence was sufficient for that, right? I mean,
Yes.
that was the verdict. That was the hope of the Commonwealth.
Yes, that was the Commonwealth's theory at trial. It was actually the defendant who had initially requested the involuntary manslaughter instruction, and then the next day changed course. And I think in an abundance of caution here, the judge, in his discretion, gave that instruction, and the judge is entitled to do so long as it's warranted by the evidence. And here, where there was some question, I think, as to whether the defendant here saw knives, and even if he did see a knife, that knife could have still been used to maim or to scare the victim. But there's nothing in the record to affirmatively suggest, whether it be by eyewitness testimony from Jennifer Hewitt or David McGurr or from the video, that there was a knife. And even if there was, when that knife was procured, as Your Honor mentioned. And there simply is no requirement that the defendant share the same mental state as his co-venturers under Tavares.
I don't want to misstate your brother's argument, but is it reasonable to have found that the defendant was not aware of the fact that the knives were going to be used in the way that they were until after the kicking, until later in the altercation, given the short time of the altercation?
Yes, I certainly think that's possible, and that's what the court found in Shim, where in affirming the defendant's conviction for involuntary manslaughter, albeit that was after a 25B2 motion. That was a case where the defendant punched the victim on the street, returned back to the car, and the SJC found that, quote, there was no evidence that at the time the defendant entered the Honda, he was aware that his co-defendant had a knife or that anyone intended to do more than beat the victim. So here, based on the evidence, a finding of malice was not required, and that's why the involuntary manslaughter instruction was warranted, and Judge Ullman gave that in an abundance of caution. I would also suggest to the court that given the defense passing reference to the jury instruction issue without legal authority, I would suggest it doesn't rise to the level of appellate argument. But if this court chooses to address it, I certainly think the judge in his discretion was warranted in giving that instruction.
Counselor, I assume you, again, no reason you aren't prepared to discuss the cases I found on lesser included instructions being improperly given?
I was not aware of those cases. I'm happy to take a look at them.
It's not necessary, just if people knew, I'd love to talk about. Do you have an opinion about the judge, I know this isn't an issue here, giving the jury a slip on the different theories of involuntary manslaughter? Do you have a view on whether that was required or even permissible?
I don't know if it was required. I certainly think it was permissible. I think from my read of the record, both theories were argued by the Commonwealth, and the jury could have convicted under either theory. I can't speculate as to why they convicted under the theory of wanton and reckless as opposed to a battery. That may have been, again, I can't speculate, but as to whether there was contact with the victim, the kicking, but even if there wasn't contact, the defendant was still effectively preventing the victim from escaping and encouraging the co-venturers from continuing that attack. And unless the court has any further questions, I would rest on my brief.
Seeing none, thank you both. The case is submitted. Okay. The next case is the next Robinson case. This time it's Gregory Robinson, 25P893.
No relationship that we know of.
Good morning, Your Honor. Shoshana Stern for the Commonwealth. This is a Commonwealth's appeal of the judge's allowance of a Rule 25b2 motion after the jury verdict, primarily on sufficiency, but he also, in the alternative, allowed a new trial. And the core issue is what constituted reasonable inferences for the jury to draw, whether the inferences of the Commonwealth circumstantial identification case based almost entirely on video were sufficient, that the jury could, within their common sense and life experience, draw them and conclude that the defendant was the shooter. And this is a case where the
common sense and life experience might get you the car, but what is the evidence that satisfies beyond reasonable doubt that the defendant who was seen in the car at the McDonald's 15 minutes earlier? How many?
well, so he's seen in the McDonald's 10 minutes earlier.
10 minutes earlier. Is the person who, in the different clothing, who fires the shots?
Yes, so when he reappears, so it's not, I don't think the Commonwealth would argue that you could conclude just, even without the clothing issue, that 10 minutes, 17 blocks away is enough to conclude it's the same car, even though it's somewhat distinctive, but not as distinctive as some cars are. But when the car essentially reappears, as I have photographs in my brief, but I think it's 6 minutes later, sort of, it goes around a series of cameras, leaving the McDonald's complex, and you see that the driver still has a white T-shirt on, or at least a white shirt, and you get a view, essentially, I compare them, it's essentially the same view as the McDonald's camera, it's the same characteristics, you can't read the license plate, but there still appears to be nobody in the passenger seat and the driver's wearing a white shirt. And then you follow the car essentially around the block, and then a dark-colored car with, I would argue the jury could conclude somewhat, not unique, but noticeable hubcap patterns and a light dashboard starts not necessarily following, but comes behind that car. And then when there's 2 or 3 minutes, depending, I think, on how exactly the seconds between that and 10 blocks away from that, you see the white car with a blue car or a dark car with similar hubcaps, sort of in very close succession, pulling into this other road where the
Am I
shooting
right
takes
in
place.
thinking that's about 2 minutes before the shooting?
What?
Do I have the timing wrong? It seemed like that was about 2 minutes before
Yeah,
the shooting.
that essentially you.
It's like
you see-
11:53, and then the shooting's at 11:55.
Yes, so like 3 minutes before the shooting, you see a crisp image of the car where you can't see the license plate, but you can see what the driver's wearing, as well as you can see at the McDonald's. And then, or at least as well as you can see from the front McDonald's camera. And then you see what the car is doing from a close set of cameras over the next about minute. And then there's 2 minutes essentially and 10 blocks. And that's not obviously, you know, that's not, there's absolutely no way, but is that beyond a reasonable doubt in that period of time that that the jury could conclude that it is the same driver who was put on a sweatshirt as opposed to somebody else is suddenly now driving this car?
Maybe a small point, but is there any indication in the video or otherwise that there are any stops or lights or anything that that the white car would have gone through between the time the person in
Yeah.
the white T-shirt is last visible and the time of the stop for the
Well,
shooting?
not in the video, because that is the last video of on North. I think that there's testimony that is the last video between the two locations. It's not that there's other locations that don't show it. There's 10 blocks of North Front Street, which is a major road, but I don't know that there is specific evidence of whether or where there are lights. There are certainly lights in various videos. You know, it's a busy area, but we don't know. There's no evidence specifically of that. That is true.
So why is the evidence here stronger than Gonzalez or Swafford? In both those cases, there was motive. Here we don't have any motive. In both those cases, there was consciousness of guilt. Here you argue there is consciousness of guilt. And a strong possibility that it could have been the same car and the same driver. But in both those cases, the evidence was insufficient. Why is this one better?
Well, in Gonzalez, I believe, I mean, Gonzalez, again, had very complicated facts that, in a lot of context, but as I recall, they had a video expert trying to show, essentially it's a Dodge Caravan. And the question is, does it look like, and the victim was also driving a Dodge. So you have two Dodge Caravans, and the question is the suspect car Dodge Caravan consistent with the victim's mother's car? And essentially the expert was only able to say that he couldn't exclude it. So that's very general. And again, you know, that's, as they note, there's two Dodge Caravans in that case. And in this case, we have essentially there is more detail, there is more information about, you know, as in Baxter. Baxter has a more distinctive looking car than this case. It's got a smashed bumper, it's got a scratch in the door, but essentially it is a case where I think there's a 5 or 6 minute gap where you follow it on video and they infer that the driver is still the driver.
What's the distinctive characteristic of this car that's in some way not stock? The wing, the black markings, the hubcaps, other than arguably the placement of the license plate?
Well, I think it's key to our argument that we're arguing it's distinctive enough for this time and this distance and this space.
Based on the videos taken
Based on the
place and lack
videos,
of
that we
other
would not
cars.
argue you can identify this car in the world, or even, again, I don't think we would argue that just having it at McDonald's and having it 10 minutes later would be enough, but that with the intervening sort of footage of the car, the off-center license plate, it's, again, I know that there's a lot of sort of discussion in my brief and from the judge about whether statistics would help the jury, and I argued that, I'm just not sure that that is in fact something that in most cases would be admissible as a reasonable, you know, knowing how many of a car of a certain make and model or type in an area is not going to tell you who was actually there at that particular, you know, if there's only 3 of these in all of New Bedford, they could have all been there that night on these roads. If there's 50 of them, they could have all been home. Ultimately, it still comes down to, from, you know, within the information that one can know, is that enough for a jury to conclude that, you know, that's enough on this appearance on these facts in this space at that time. Again, it's all, we're not arguing that any one of these factors by itself would be enough. It's the question of whether together they are sufficient.
Am I correct that really the only evidence here are the videos? There's nothing else.
Yeah.
So, I mean, so the judge isn't making any credibility determination.
Yeah, essentially, no. That's and I think it's a not super unusual circumstance in the sense that, you know, it's not that unusual to have a case where clearly a crime of violence was committed. For whatever reason, there are no civilian witnesses who are participating in the case. The question is whatever video is available to the Commonwealth enough to prove the case? And that'll obviously be fact-specific based on different cases, and there haven't been many of them yet, as I think the judge noted, and sort of wishing there was more guidance on it. But
I mean, sometimes you'll get there'll be some well the victim and the defendant will know each other.
Yeah.
There'll be some evidence about.
We don't know if they did or they didn't know each other. I think defense counsel appeared to expect the victim to testify that he didn't have any issues with the defendant. The victim did not testify for either party. We don't know what he told. There's no evidence of what he told anybody in this case. I think that it doesn't go to, I mean, again, I think that's a valid jury argument, as defense counsel made in his closing. But I mean, I think here it actually appears, for whatever reason, I mean, again, this is sort of, but to the extent that the blue car, or we know it's a blue car, but you can't see it on the video, gets behind the white car and seems to be following it pretty closely as they go off onto a side street 10 blocks later, you know, that looks like maybe the victims may have known other things, but if they do, they say they don't, or at least they're not in the record that they say they do.
What I'm getting at is the second argument is that you argue that the judge couldn't have found that it was against the weight of the evidence because the evidence is either one thing or another.
Yeah, I mean, essentially, I think well, I mean, I don't know. I don't want to put words in his mouth. He wrote a lot about other parts of his thinking. I mean, I know he sort of suggests that it would be a stronger case with certain sorts of evidence, and we can agree or disagree about whether that was possible. But that's not that's not weight of the evidence in the sense of, you know, this victim shouldn't have been. Weight of the evidence usually involves something beyond documentary evidence. And obviously, I mean, the nature of reasonable inferences is that there's a certain amount of space for minds to differ on what they are. Which, I mean, we would submit that in that case, you know, no matter how reasonable everyone's being, the jury outnumbers everybody and is this primary fact finder, and ultimately, if it's at all sort of within the scope, that should be left to them. If 12 people agree that this is reasonable, obviously some things are so unreasonable the jury can't do them, but that in this case, again, on these specific facts, the car was distinctive enough for the distance, for the time, for the number of videos and how far away they were to get us over that rail. And that would not obviously, there's no principle of this would always be enough, this would never be enough. It's all based on the circumstances and the totality of the situation, the time of night, the level of traffic available, what we argue was sort of an inferential potential somewhat interaction with the other car, and the fact that there's these two cars in a row, and then there's still these two cars in a row at the time of the shooting, that essentially putting all of those pieces together would enable a jury to conclude, and that a jury can sort of essentially, that how common a general appearance of a car is within the ken of the average juror, or at least, and not easily susceptible to expert testimony. Again, but again, not, I think it's a very rare case where you can say that is literally that car unless it has a giant dent or a different color door. And there are many cases where that's true, and it's like, that is seriously only that car, but that there is a range of circumstances where, again, it is distinctive enough for the rest of the evidence on those particular circumstances.
So, I mean, go ahead.
I'm not sure how important this is, but would you agree with me that, at least as far as the video is concerned, there isn't video that shows both the dark car following the white car, if that's the way you characterize it, the dark car and the white car together in the same video, and also shows the driver of the white car wearing a white T-shirt?
No, the driver of the driver of the white car is, well, the face of the driver's, well, the defendant is only visible at the McDonald's. Everyone agrees he's there. You can see that there's a driver in a white shirt as at the first camera, I think, after the McDonald's, and then as it goes around the block, the blue car is behind it at the next two. You know, I don't know that we argued particularly that anybody knew that was that was necessarily anybody's plan, but that the blue car in the last two of those cameras is behind the white car, and then is still behind a dark car with similar hubcaps is pretty close behind a white car with a number of similar features and silhouette, et cetera, and the off-center license plate, off-center on the same side as they drive down Tinkham Street, and the white car comes first, pulls over, and as the blue car shoots by, the driver shoots into the windshield and again, or into the driver, or the passenger side window, and again. So we would argue the jury could take into consideration all of those by themselves fairly small pieces of information to argue that it paints a total picture.
So you're saying the jury, are you saying it's the jury could use their life experience and common sense to think license plates don't usually appear on the side like that?
Yeah, I mean, I know the judge sort of suggested it would be good to have expert testimony on that. I'm not sure what expert testimony you could get, but I think that's one. There is a wide, I mean, as in with DNA, the SJC said this is not like what features of people look like. You know, you can go around the world seeing what you think is common, but you can't do that. You can't see DNA.
I mean, suppose there was there, I don't know if there's there must be, you know, if there was an overnight and the jurors went home and came back, you know, if during the, you know, during the trial, the jurors said, let's go out on the street and count cars and see where the license plates are. They couldn't do that, right?
Well,
I mean,
no, they shouldn't do that. I will say that having stared at the video in this case, I cannot help seeing every car of relevant make and model and features but that's just the brain.
Right.
But
it would
not be, that would be doing their own research. But if their immediate thought was, I don't think I hardly ever see off-center license plates. I mean, I don't know how you deal with getting the jury not to, I mean, yeah, but again, it's sort of in the world you see a lot of cars, and you might or might not, some people notice everything about cars, some people don't notice anything about them, but you have a sense of sort of, does every other car look like this? Are they all Dodge Caravans, essentially? All right, no further questions?
Seeing none.
The Commonwealth rests
Thank
on
you.
its brief.
Okay. I think we'll go to 4.
Good morning, Your Honors. Brent Wenick on behalf of Gregory Robinson. May it please the Court, I'm asking you to uphold the trial judge's decision to grant the defendant's Rule 25 motion, allowing the renewed motion for required finding. I would suggest this case is a series of could-bes, maybes, possibly that it was the defendant, but the Commonwealth is relying on a series of inferences that, even coupled together, do not permit the jury to, even in the light most favorable to the Commonwealth, reach the ultimate conclusion that Mr. Robinson is the individual shooting beyond a reasonable doubt. I would start, I think the trial judge in his ruling, mentions a series of inferences. I think the two that are most significant certainly are, is it the same car from the McDonald's to the crime scene? And then secondly, is it the same individual driving that car, if it's the same car? And that's ultimately one of the issues in this case. You have to stack both of these inferences together to reach that conclusion that Gregory Robinson was the individual that shot at that car.
But even if we assume it was the same car, is the more important question whether it's the same person?
I would suggest that the Commonwealth's argument about the car is a little bit stronger than whether it's the same person. I do concede that it certainly was certainly Mr. Robinson at the McDonald's. That was not disputed at trial, not disputed at this point. I would suggest that the evidence doesn't, conclusively show that it's the same white Honda. White Honda, very popular car. The Commonwealth put in no evidence to suggest that the things that they argued, throughout the trial, the sunroof and some of the bumper panels and so forth, were even anything remarkable. There was no evidence that these are, we don't even know if this is a standard for that type of vehicle. There was no evidence of that. The same thing with the license plate. Now, granted, I would concede that the license plate is perhaps the Commonwealth's stronger argument, the off-center. I would suggest two things. One, I don't think it's crystal clear. That video is a bit grainy at the scene. I did some of the citywide cameras, leading up to the shooting, show that a little bit more clearly. Certainly, the McDonald's video shows the license plate being a little off-center, more clearly. The video, the surveillance video, is from a little bit of a distance away. It's not of enormous high quality. I don't think it's certainly enough to reach a conclusion that it's definitely off-center. And then there's just no evidence, once again, there's no evidence that Commonwealth could have presented, for instance, and it wouldn't be statistics. They could have had someone, an officer take the stand and say, look, the license plate's supposed to be in the center of the car. I'm pretty sure that's, by, regulation, and they didn't do that. They didn't, try anything to suggest that, these the sunroof, the different panels that they kept referencing were in any way, specific to that model. Or they were aftermarket items. There was no testimony to that.
So how do you distinguish Baxter, which is the video following the car case?
So in Baxter, I mean, I think what separates this case, I think, from some of the other cases is that in other cases there's other evidence. Here, this is the only evidence that the Commonwealth has. They don't have any motive of any kind, which I realize they don't have to prove motive, but in this case...
Well, what is the evidence that they do have in Baxter that you don't have here?
If I recall Baxter, Your Honor, I'm drawing a blank on that at the moment. What I would suggest is I don't think there's a case, and I don't remember the specifics of Baxter, that where there is just these, combination, multiple inferences together that allows for the defendant to be found guilty. And I would suggest that in this case, I do think the stronger argument is that whether that's the same individual in the car. So even if you get to the point where, and I would concede that the Commonwealth's argument is a little bit better on that front, whether the car part. I think the second issue is the harder issue for the Commonwealth to overcome, is that there is definitive video of an individual in a sweatshirt or a jacket, and the trial judge ruled it was either, or determined it was probably a sweatshirt or a jacket. I think the video is consistent with that. That is completely different than what Mr. Robinson was wearing, and there's enough gap, between the last video that shows a white shirt and the shooting, where I think there's two possible outcomes here, where it's either what the Commonwealth is asking for, which is that, Mr. Robinson must have put on a sweatshirt or jacket, which we don't see in any of the vehicles, the surveillance videos, excuse me, of him there being any sort of sweatshirt or so forth. Like the McDonald's video, you can see him a little bit up close. You don't see anything like that in the car. Or that there's someone else, switch places. I think that those are two equally reasonable conclusions, and the jury would have to be able to find someone guilty beyond a reasonable doubt, reach the conclusion that one that the Commonwealth is asking for is the only one that's possible, and I don't think that's the case.
Well, are they equal? I mean, there's three possibilities, right? It's the same car and the same person he put on a sweatshirt. It's the same car and a different person. That seems less likely. Or it's a different car and a different person.
Well, Your Honor, I would suggest that, there's not enough evidence, in this case. I would agree that the evidence doesn't appear that there's someone in the passenger seat when the car is in the McDonald's parking lot. The back of the car is not, completely obvious, and certainly not in that first camera, in the citywide camera. So, there's a possibility there's someone in the back of the car that is not really, been contemplated by the Commonwealth. I mean, there are alternatives here where there are multiple people in the car and ultimately they switch places. All of those are possibilities. And for Mr. Robinson to be found, guilty, you have to, I would suggest, relatively equal possibilities, and that the one that the Commonwealth is suggesting without any other evidence, corroborating, physical. There's no cell phone data in this case that puts Mr. Robinson at that scene. And I would suggest, like I started to say about with respect to motive, in this case, it appears on the home surveillance video that the white car, pulls to the side, and the dark colored car comes to almost a complete stop. And there's no stop sign. That was in testimony by the officers that responded to the scene. There's no stop sign, there's no lights, there's really no conceivable reason why that dark colored car would come to a complete stop for what appears to be a few seconds. It would suggest that there was some sort of communication between the two vehicles, yet there's no evidence of that. And so and I was once again suggest that that's sort of for the Commonwealth to, make the argument, though, that it has to be, Mr. Robinson's car. Well, they don't have any answer as to how Mr. Robinson would go from McDonald's and then 10 minutes later find this vehicle and, and shoot at it. And I think it's just as possible that for that to happen versus someone else getting in that car or just people switching out of the vehicle.
I'm not following this. I mean, it's got to be a crime of happenstance, because if you're seeking to attack someone, you wouldn't get in front of them, you'd get behind them. There must have been some kind of road rage, or they recognized each other as rival gang members. I don't understand why that means it couldn't be him.
I suppose, but once again, there's no evidence of any connection between the members of the one vehicle and Mr. Robinson. I would suggest that the stopping of the car, the dark colored car, for quite a few moments, but it's inconsistent with it being a stranger crime. I would suggest I would concede it's possible that what you're suggesting it may be is true, but once again, there's no evidence of that. If there was evidence that these parties knew each other, Mr. Robinson knew these people, that their evidence would be stronger that it's actually Mr. Robinson.
Why is that? Why is the fact that it's probably not a stranger situation helpful to you? Maybe you're not even saying that. It seems like if it was a non-stranger situation, make it all the more likely defendant would, put on something warmer and darker before engaging in combat.
I'm sorry, I didn't.
Well, if it's a non-stranger situation, doesn't it make it more likely that the defendant would put on something warmer and darker before engaging in combat?
If it was one argument would be that the shooter's putting on this stuff to conceal himself. If they know each other, there's no reason to put on anything to disguise. Or maybe I'm not understanding your.
You don't think that if you're going to shoot someone in the dark in a snowstorm, you'd rather be wearing something warm and black?
I would agree that most people, more people wear sweatshirts in March than T-shirts. But what you have in this case is an individual wearing a T-shirt, and then the shooter wearing a sweatshirt with no evidence that Mr. Robinson has a sweatshirt in that car or seen at any point that night with the sweatshirt on. Once again, I mean, the Commonwealth has to be able to establish that the person in the white T-shirt at the McDonald's, Mr. Robinson, is the person that walks out of that car.
I think we understand your argument. You have more time if you like, but
I have finished over the rest on the brief.
Okay. Thank you both. The case is submitted. So normally we take a break after 3 cases, but that would be at about 11. But we've been going pretty quick today, so we're going to hear one more case before our recess, and that'll be case number 4 on the list, which is Weeks versus Beard. So the appellants come up and sit over here. The defendant's over here. I don't think you were here when I gave the introductory spiel. Have a seat. It's 25P 428 Weeks versus Beard. It's 15 minutes per side here. There's no rebuttal. So it's a yellow light goes on when there's a minute and a half left. A red light goes on when it's time to stop. You're free. You have 15 minutes. You're free to use them, but there's no penalty for stopping early. We've read your brief, so we're familiar with the case. So come on up, and it's. Go ahead. Yeah. So you're Ms. Weeks, I take it.
TALITHAANN WEEKES.
Okay, and you're with Mr. Caldwell?
Yes, my son.
But you'll be doing all the arguing?
Yes.
Okay. why don't we start with this? What do you think is, like, what is the most important issue in this case that the trial court got wrong? What do you, that you've argued in your brief? What is your most important issue?
I wasn't treated right throughout the whole case.
So what were some examples of that?
Okay. From the beginning of the case to the description of the case, it was biased. It favored the defendant over telling the actual story. The judge was wanting us to agree on a joint description of the case. You can't agree when it's two different stories. One's the truth and one's not the truth. I'm going to read from my notes.
Okay.
Bear with me. Good morning, members of the panel. Thank you for having me here today.
Do you need a glass of water? There's.
Yeah.
Careful, sometimes it spills all over the place, so.
I'm sorry, this whole thing just makes me, I went through a lot. Thank you. The various issues surrounding the lower court's conflicting rulings in my case is as follows, and is supported in my briefs and appendix. The description of the case was biased. First, the trial judge wrote the description to favor the defendants. The trial judge exhibited biased behavior from the start of the pretrial to the end of the trial, and his actions showed an abuse of his discretion. The trial judge during pretrial disagreed with his previous ruling that was read to support our opposition against the appellees. Multiple motions in Lime. See Appendix 2, page 21, paragraphs 11 through 12. The trial judge displayed bias while we presented our exhibits stating, "I don't care what the southern artery looks like," causing my counsel to respond, "Well, it's going to become irrelevant after." The court responded, "I'm sure it will." See Appendix 2, page 192, paragraphs 20 through 23. During trial, the court asked appellees, "Are you all right? You're not objecting at this point? All right, go ahead." See Appendix 2, page 208, paragraphs 17 through 22. The trial judge showed persistent favoritism towards the appellees, including but not limited to Darren Griffin's testimony. He was on the phone with me.
There's a part in your brief where you talk about there being 3 back-to-back objections sustained. That was during Mr. Griffin's testimony, is that right?
Yes.
And it was that he was being asked to say what you said to him over the phone, right?
Yeah, so there were so many objections. Like before the trial case started, the judge said, "Is everyone ready to go? Trial's ready to start." There was no objections or anything. On the day of trial, when we were supposed to start, when my witnesses were supposed to testify, they objected to having my witnesses testify. Then he allowed the other attorney to do a deposition, even though we were supposed to start trial. It was like all my witnesses were basically blocked. None of my witnesses were going to even testify at first.
And the depositions took place over a weekend, is that correct?
Yeah, on the morning she was on the phone, like trying to get with her kids. She never tried before then to reach out or depose my witnesses. I'm going to continue reading from my notes.
Sorry to interrupt.
No, you're fine. The trial judge showed persistent favoritism towards the appellees, including but not limited to Darren Griffin's testimony. He was on the phone with me when I went to the tow lot. The court gave no reason to exclude his testimony of what he heard, and that prejudiced my case. See Appendix 3, page 151.
I'm sorry to interrupt you again, but if he had been permitted to testify, what would he have said?
That he was on the phone with me the whole time when I pulled up to the tow lot. He didn't hear me talk to I never had any interaction with Roger Beard. He didn't hear me conversating with anybody. He didn't hear anything. He was on the phone with me when I pulled up to the tow lot until I left to go pick up my son from after school.
Okay, that's helpful.
The trial judge interrupted our 13-minute closing arguments, asking when my counsel was going to be finished when she had ample time left to argue. Our closing argument was directly related to the evidence entered at trial, including Moika, which is one of my witnesses, testifying she learned of the news coverage on Facebook about Roger. The trial judge, in reference to the issues at trial, admitted problems with the trial. This problem started with the appellee's objections during trial. The trial judge stated the problem we're having in this case is the lack of communication before trial. See Appendix 2, page 12, paragraphs 10 through 16. The trial judge contradicted its rulings, such as allowing the witnesses to testify and then blocking them from testifying when they took the witness stand. See Appendix 3, pages 6 through 17. The court allowed appellees to do a last-minute deposition that was inappropriate. Defense counsel's children were screaming very loudly in the background. My witnesses were available during discovery set by the court. The court abused its discretion for all the reasons stated in my brief and reply brief. According to Commonwealth, 1st Edward Long, 485, Mass. 711-740, 2020, if systematic racism is defined as a system or institution that produce racially disparate outcomes, regardless of the intentions of the people who work with it, then our system is rife with it. The appellees contradicted themselves numerous times in attacking discovery during trial and failed to substantiate any of their faulty arguments. The appellees state the following, included by not limited to denying Joanna was disclosed previously when she was on April 29th, 2024. Joanna was one of my witnesses. She was blocked out of being able to even be a witness, even though she was on the document, because the other attorney lied and said that she never had any recollection of her being a witness. So the judge automatically took her off. So I had to go back and reference and find the actual date. And when the attorney was going to tell the judge that we have it in the paperwork, we submitted it through the courts and everyone. And he said, basically, she told the clerk, and he said, don't interrupt or he'll let you know. But she was never able to testify at all during my trial.
And what would she have testified to if given the opportunity?
She was, sorry.
Okay, take your time.
She knows a lot of my story. We was studying in school together. Like, we went to school together. I was with her every day. She came around me. She helped me She's seen the news media coverage. She knows.
So after she would testify about what happened after the fact.
Yeah,
Thanks.
yeah. Okay. Let me find. Okay. They denied Makiba's last name was on the interrogatory when evidence shows that was not true. Makiba's last name was on the interrogatory. See Appendix 3, page 8 through 9. The appellees denied they signed a joint pretrial memorandum when that was not factual, as shown on the docket sheet in the lower court. See Appendix 1, pages 141 to 149. During discovery, appellee stated at the deposition to me, "I'm not asking you what is Darren Griffin's phone number, email address, residential address," yet claimed they were not given any addresses, and they objected to provide residential addresses for their clients during discovery. See Appendix 3, pages 6 through 17. Defense counsel did a back-to-back objection against my witnesses, and the court entertained it. We informed the court about appellee's non-factual argument, but the court treated us unfairly. The court disregarded our argument regarding the appellee's false information. The appellee's counsel throughout the trial was disrespectful, such as yelling in my counsel's face, shrugging at the court, and the court asked her not to. See Appendix 3, page 28, paragraphs 19 through 124. The defense attorney's mother was disrespectful in the courtroom towards me, my witnesses, and my son. As stated previously, the court admitted the problem we're having in this case is the lack of communication before trial. The court was notified by us of the defense faulty arguments, and the only solution by the court is to tell counsels to watch experienced trial lawyers. This never happens. It never happens because they talk to each other before. And if there's an issue, they bring it to the judge before. This should never happen with the witness in the box. It never should. See Appendix 3, page 12, paragraphs 10 through 16. See also Appendix 2, page 12, paragraphs 10 through 16. We filed a motion for a new trial with evidence, and the judge made a plain denial. After trial, the appellee's attorneys attempted to bribe us in her email dated January 29, 2024, stating that she agrees not to pursue recovery of our costs and fees in exchange of my dismissal of the entire matter, which would include me notifying the court that I'm withdrawing my appeal. The attorney's costs and fees should be a deflection bearing recovery of any fees and costs, include but not limited to the deposition of the police officer that was taken after the discovery deadline set by the court and appellees. And the deposition at trial was not in compliance of Rule 30 that requires 7 days before the deposition is taken, and this is prejudice and prevented us from doing cross-examination at the deposition. There were conflicting decisions by various lower court judges, resulting in my claims for false imprisonment, false arrest, and negligent infliction of emotional distress to be dismissed. This created an injustice. My claims survived the appellant's motion to dismiss, and under anti-SLAPP statute as indicated on pages 16 through 23 of my briefs. Whether or not a lower court's ruling can be changed by another lower court's ruling when there are no changes in our evidence and no exceptional circumstances where case laws and/or law has changed. My case was about a sham and/or fraud committed by the appellees, and no new case law has changed the standard as it pertains to sham under the appellees' anti-SLAPP motion that was untimely filed, the law of the case doctrine. I know I'm running out of time, but I'm just asking to be granted a new trial for all the reasons I was able to state in my brief. Thank you guys for listening. I hope that you guys look over my briefs and appendix and consider me getting a new trial.
We will.
Thank you.
Thank you. We'll hear from the defendant.
Good morning, and may it please the court. My name is David Zizik, and I represent Penn America Insurance Company. Early on in the case, as I think you probably know from my brief, the judge severed and stayed the Unfair Claims Practices Act 93A 176D claims against Penn America. So Penn America was not involved in the trial below, but I did want to underscore very briefly and then yield the remainder of my time to my brother. I want to address point out that there was a waiver, I believe, of any right to press Judge Layton's dismissal of these claims following the jury trial, because there's been no argument presented, not only today, but in the brief. Nothing.
Wasn't that dismissal based solely on the fact that the verdict was against the plaintiffs?
It was not specified in the order, Your Honor.
What was your grounds for moving to dismiss it?
We moved to dismiss or sever and stay. The court did not address our dismissal motion. Simply severed and stayed that. So no, I mean, what you're asking is,
the court
was it dismissed on the merits?
The court sua sponte dismissed without, and no one knows why? Is that what you're saying?
Well, there were no reasons stated in the order other than a dismissal. I'm presuming that Judge Layton dismissed those claims based on the jury verdict, because there can't, as a matter of law, be a finding against the insurance company for failure to settle a claim in which there was, in which liability could not have been reasonably
So why
clear.
wouldn't that mean that if we reversed the jury verdict, that the claims against the insurance company would at least return to stay status to see what happens on the retrial?
The court has the discretion to do that, I would concede.
Right.
So unless there's anything else the court would like to ask me, Penn America rests on the brief.
Thank you.
Thank you, Your Honor.
Good morning. My name is Peter Kober, and I represent Roger Beard and KBR, who are the defendants in the underlying case. The nexus of the plaintiff's appeal, as I heard this morning and as I have gleaned from her brief, is that there was some kind of underlying bias which occurred not only at the trial level but throughout the pretrial, and which involved all of the Superior Court judges, apparently except for Judge Cosgrove, who made the first decision. With respect, there was no bias. And I say that because the record, both in terms of the trial transcript and in terms of the rulings that are part of the record that relate to the summary judgment motion that was filed by the defendants, as well as the second anti-SLAPP motion, which was filed by the defendants, are explained in rather great detail. And the legal basis for those is not only very well explained, but I would submit is legally correct. And indeed, the plaintiffs in their brief have not really attacked any of those particular rulings, except insofar as to say, well, it looks like the judges are suddenly contradicting themselves. And the problem with that argument...
But it seems like she's challenging whether there was properly summary judgment on the negligent infliction, whether there was a duty on the part of Beard.
Correct. That is certainly one of the things that she has objected to. And the basis for the ruling, if you read the summary judgment decision, was that there was no evidence which supported any theory that the tow yard, the defendants, had a specific duty of care as a tow yard operator toward the plaintiffs. And there was, in fact, no evidence presented to that, and there was no articulation of that particular argument.
I mean, it seems odd that in a involuntary tow situation, that the tow company wouldn't have some duties to the owner of the vehicle to secure the vehicle, to take care of it while it's in the tow lot. Wouldn't you agree there's those duties?
Oh, I agree. And certainly you can't, although I suspect anyone who has had the misfortune of having their car towed.
I've had that.
Probably, me too, probably thinks it wasn't done appropriately. But in this particular case, the tow yard received a call from the Quincy police that this car was being parked illegally and should be towed. And it wasn't up to the tow yard to dig into the weeds whether that was a correct or legal determination by the Quincy police. Their job is when they get a call from the police to tow a vehicle, they tow the vehicle. And that is what their duty is. And they then have a duty to tow the car safely to the tow yard, which they did. No damage occurred. And then they have a duty to maintain the vehicle safely, which they did. There was no damage done to the vehicle. There was a claim that was made that $20 were apparently missing afterwards, but there was no evidence presented in the summary judgment record which indicated that they had done anything incorrect.
Wasn't there an allegation, though, that the tow fees were hiked? That it was there not an allegation that the tow fees were hiked? So it wasn't simply recovery of the fees, at least as alleged.
Well,
maybe some conflicting allegations about.
I don't believe there was evidence that the tow fees were hiked. I believe the evidence was they were charged for getting their vehicle towed twice. And then what they actually did was the price for towing two vehicles, according to the record, according to Mr. Beard's testimony, was $380. But in fact, he only charged the plaintiff $340.
After adjusting the total down from 500 and something.
I believe so, yeah.
Can I ask one other question? Did the negligent, am I misreading the complaints? And I don't think it matters which one, but the complaint that was at issue in the summary judgment, at any rate, to say that the negligent infliction claims also included a component that had to do with the false reporting of the claim to the media? That was something beyond just the tow? And if that's true, how does that affect the summary judgment?
Your memory is better than mine. I honestly don't recall. Certainly, the heart of the plaintiff's case was that what the defendants had done was they had gone to the media after the fact, and they had falsely reported certain facts about the plaintiff. And there was testimony from Mr. Beard that he had towed the vehicle because he was told by the police. Subsequently, it turned out, I guess, that Mrs. Weeks was able to fight the ticket and was able to get it dismissed. But the point is that at the point that Mr. Beard was speaking to the media, for all he knew, it was a perfectly lawful ticket, and he did what he was told to do. There was a contention that I believe in the person of Mr. Salmons, who was the co-employee or the only other employee of the tow yard, that he had somehow submitted a false affidavit to the police, which had been part of the evidence that they had used to arrest her. Mr. Salmons subsequently withdrew that, And the tow yard said, and Mr. Salmons, who testified at the trial, specifically said he didn't speak with her afterwards. So the jury had the opportunity to consider that in any event. Whether the
I'm talking about the summary judgment, at the summary judgment
summary
level.
judgment? Well,
It's
it
a
was
verified complaint, so
Mr.
there's
Salmons
some.
had been deposed, I believe, by that.
I didn't hear you.
Mr. Salmons had been deposed, I believe, by that point. And so that was the testimony that he gave, and it was similar to what he had testified to at trial, which is in the record. So one of the things, of course, that was brought up was that the court reversed itself as far as dismissing the false arrest, false imprisonment claims that were originally denied in the first anti-SLAPP motion. And the reason why the court reached a different decision when it was raised the second time was because in the original decision, Judge Cosgrove had said that the false arrest and false imprisonment claims were factually supported and they were legally defensible. But he said, well, the claims are colorable. And under the original anti-SLAPP test, if a claim was colorable, then it survived an anti-SLAPP motion. Subsequently, in light of the Bristol asphalt and the Columbia Plaza cases, the test of whether a claim was colorable or not fell out of the anti-SLAPP analysis. And so that's why the motion was decided the second time the way it was, because Judge Cosgrove had already decided, and I'm sorry, Judge Cloutier, I believe, was the judge who decided the second anti-SLAPP motion. She obviously agreed with Judge Cosgrove's decision that it was factually correct, or at least factually supportable, and it was legally supportable. And so if the question of whether or not the claim was colorable or not was no longer part of the analysis, then the anti-SLAPP motion was successful. And that's what happened. And that's not a contradictory ruling. That's a ruling which is consistent with a change in the law that was made by the SJC in those cases.
Counselor, I noticed that in May of last year, the parties agreed to have the SLAPP fees decide on the papers.
Excuse me?
In May of last year, the parties agreed to have the SLAPP fees in the trial court decide on the papers.
Correct.
And I didn't see any follow-up on that.
Well, that's because we're still waiting for a decision from the Superior Court.
All right. Still waiting.
Now, as far as Judge Layton's decisions relating to the conduct of the trial, you have the transcript and you have an opportunity to see how he conducted himself, how he ruled on the evidence, how he interacted with counsel. And I respectfully submit that he treated the plaintiffs fairly, honestly, and without bias. What he did say to them at the point where they were still representing themselves, which was before the very last pretrial conference when they got counsel who tried the case for them. What Judge Layton said was, what I'm going to say to you may sound like I'm mean, but the context of that was, I have to apply the rules of evidence fairly and equally to everybody. And whether or not you are lawyers and don't know the rules of evidence, they apply to you as well as they do to anybody else.
In that vein, your time is up.
Okay.
And we've got your
In
brief.
that case,
so-
I will respectfully submit. Thank you.
Thank you both. Thank you both. The case is submitted, and we're going to take a morning recess. Back in about 15 minutes.
I don't think we.
Court is in session. Please be seated.
Okay, we're back on the record for 2 impounded or partially impounded cases, so let's not use names. So this is in the matter of SC 25P890.
Thank you, Your Honor. Good morning. May it please the Court. Karen Talley on behalf of SC. SC asks this Court to vacate the guardianship on 3 different grounds: that the original guardianship was void at its inception, that SC does not presently meet the criteria for guardianship under the MUPC, and that SC should be granted a new trial based on ineffective assistance. And I'd like to start with number 2, that SC does not currently meet the requirements for guardianship, and that will somewhat address why the initial decree was invalid. The one thing in this case that everyone seems to agree on is that the guardianship was entered when SC was probably at what was the lowest point in her life. She'd been the victim of domestic violence, homeless, lost custody of her child, and was suicidal. She was in crisis at that time. She had multiple hospitalizations between 2016 and 2018. Also not in dispute is that her family stepped in to help her at that point, and they sought guardianship partially as a way to do that. SC herself agreed that she needed help at that time, and she basically assented to the guardianship. It never went to trial, and I think that's also an important factor here. It was accompanied by a Rogers order for antipsychotic medication, which had been prescribed as an adjunct to the antidepressants at that time. It is also beyond dispute that SC has made some poor decisions in her life and needs support in learning how to make better ones moving forward. But the MUPC is a reform statute aiming to reduce unnecessary guardianships by looking for alternatives, tailoring and limiting those that are necessary, and then reviewing them to see if some point down the road the rights can be restored, maximizing autonomy and self-reliance along the way. And the primary way that the MUPC seeks to do this is at the outset with a very robust, multi-part definition of incapacitated person. And I'll just read it for the Court. An individual, for reasons other than advanced age or minority, has a clinically diagnosed condition that results in an inability to receive and evaluate information or make or communicate decisions to such an extent that they are unable to meet essential requirements for physical health, safety, and self-care, even with appropriate technological assistance. So there are multiple parts to that definition. There's a cognitive part, there's a functional part, and there's a less restrictive alternative part. And that was one of the fundamental aspects of this reform. And the precision of that definition and the accuracy of the clinical condition that's identified matters. And this is also why the cumulative errors the court made in its findings also matter. It's not really enough to say some sort of developmental delay or learning disability when the person was a child that may or may not be affecting them as an adult. It's not enough to say mental illness. And the reason why precision matters in defining the clinical condition is tied to the goals of the MUPC. If the clinical condition isn't precisely defined, the court doesn't know if it's a past diagnosis or a current diagnosis, if it's temporary, if it's amenable to less restrictive alternatives to guardianship, if it lends itself to a more narrowly tailored guardianship, and if it should be reviewed down the road to see if it can be either further tailored or the person's rights restored. And this is also in part why the statute requires the guardian to file what are called care plan reports. The initial one needs to be filed 60 days after the guardianship decree is entered, and then yearly thereafter. And unfortunately, in this case, even though those are court orders, the guardian didn't comply, never complied, never filed a care plan report until 2022, after this petition to terminate was filed.
Maybe taking this totally out of order, and I
Yep, that's fine. No, that's fine.
But with respect to the less restrictive alternative argument that you're making, my understanding is that the only less restrictive alternative that you're suggesting, at least in your brief, is that there be if the order is going to be issued, is that the decree, that the guardian be required to continue to promote SC's independence. Is that true?
I did mention that in my reply brief, and I appreciate the question for the clarification. That was really just by way of saying that there's multiple ways that on the ineffective assistance claim that it's not sort of a dichotomous test, like, you know, you have to demonstrate that the person wouldn't have been convicted. It
Right,
was
but
really,
don't you have to tell us what lesser restrictive alternatives the lawyer could have advocated for that the judge would have smiled upon?
in terms of the ineffective
To win an effectiveness claim,
assistance?
you've got to show prejudice. You've got to tell us
Yes.
what that would be.
Yes, and unfortunately, in this case, the act that was ineffective was not to follow up with the 4 experts that were employed at trial to have
Again,
them discuss those.
To win an effectiveness, don't you have to show us those experts would have said this could have been elicited? I didn't see any of that in the affidavits I know you didn't write
Yeah,
the motion for new trial, but
yeah. and-
I didn't see any showing of any prejudice there.
Yeah, I think that in terms of the motion for funds to supplement the motion for a new trial was maybe not timed correctly to get those affidavits from the experts. So I acknowledge that it could have been more robust on describing exactly how the experts would have opined. But by the same token, the experts did not opine about less restrictive alternatives that would keep the guardianship in place. I think by less restrictive alternatives, what was meant, each expert was very clear that they thought she doesn't meet the definition and criteria for imposition of a guardianship at all. By less restrictive alternatives, what was meant is things like what was identified, that everyone's in agreement. She does need help with making decisions. She's made some very poor decisions, but that can take place, that kind of assistance can take place outside the context of a guardianship. And in fact, that's how she has learned, that's how many people learn.
Sorry.
It seems to me that you need to either tell us why Dr. Sella's testimony is not enough to establish a guardianship or why the judge couldn't believe it, couldn't credit it.
Yes, yes, and I'd be happy to do that. Dr. Saleh's testimony, which I agree, you're correct that the judge did credit Dr. Saleh's testimony and in fact seemed to credit it over the testimony of her own experts. It seemed to be primarily based on the erroneous, I think, finding that he had reviewed a vast amount of past medical records and that her own experts had not conducted such a review, and that he paid closer attention or gave more weight to the role of a mental illness in the past and how that created risk in the future. And the reason why I think that is erroneous, or why Dr. Saleh's opinion was given more credit than it should have been, again, ties back to the MUPC, which is to look at current capacity and not to be a backward-looking exercise in which, and I'm paraphrasing, but I believe Dr. Saleh opined and the judge found that someone with these multiple hospitalizations and suicidality 6 years before and who picked up various diagnoses along the way with these acute hospitalizations when she was at her worst, that someone you can never do well enough or get far enough past that for that not to be either the most salient information or at least very salient information. And so that is a backward-looking analysis that I think risks putting the person into exactly the kind of box that the MUPC was looking to avoid. The MUPC, the reforms, were looking to not put people into a box tied to their past performance or ability or wellness or crisis that they can never get out of. And SC was really in that kind of a box, no matter how well she did.
It's not clear to me whether there is, your client's position is that there was no diagnosis available or that borderline personality disorder was not a current diagnosis at the time that the trial took place. Can you clarify that for me?
Yeah, and it is very confusing. And I think some of her experts believed different things. Her experts believed either that it was not a current diagnosis, or if it had been a diagnosis or she had some traits that led to that as a plausible diagnosis, she could, and Dr. Gray and specifically, by someone reaches their 30s and their 40s, that can be in remission. But it was very unclear, and even Dr. Saleh did not ascribe her that diagnosis. He said the past medical records talked about traits, but she never met the full criteria, and her treating clinician also, Dr. Julian, was not treating her.
The extent that the judge found that that was or we infer that the judge found that that was a current diagnosis, is that error?
Yes, I think it's error, and I think it's significant error, because I think that tied into the reason why they thought she would never improve. They talked about it, I think, as being something that doesn't go away or something you can't shake off, and they tied it to the impulsive behaviors, the poor choices in relationships, the manipulation, with respect to credit cards and things like that. So that was, I think it was an error, or we argue it was an error, and it was a very significant error.
Can I ask another, unrelated to that current stream, a burden of proof question? It seems to me that at trial, the judge and the parties took the position or operated under the assumption that the burden was on SC to prove that a guardianship was no longer required or a modification was required to the guardianship. Is that your position?
Yes. Thank you. That's a really interesting question. I really appreciate it, because I've given it a lot of thought. It seems plausible on its face that she was the moving party. She was petitioning to undo something that was in effect, and so it seems plausible that the burden was on her by a preponderance. But in the facts of this particular case, because the decree had been entered with no trial by her assent, and yet also alleging that she had a 44 IQ at the time she was assenting to the guardianship decree being put in place, and the lack of care plans that were filed by the guardian or Rogers Renewals that could have brought her before the court when she didn't have the burden. And in her petition, she contested the validity of the initial decree. So in a situation like this, my ideal position would be that she has some burden to come forward, and then at some point it shifts on the facts.
I thought there was an appeals court case written by Judge Maldonado from like 2018 or 17 that said exactly that. Am I mistaken?
I can't think of it off the top of my head, so I apologize. But yeah, I think that given that the facts were never tested, not contested, but never tested at trial, then I think the burden shifting on the facts of this case is appropriate, meaning she has to come forward.
Just one thing, can you help me clarify? You spent a lot of time on this in your brief, that there was an error that the judge thought that the guardian had continuing Rogers authority.
Yes.
And that somehow affected the findings, and also your counsel was ineffective for not clarifying that. And then there's finally the order at the end includes, well, it's that the guardian's authority includes monitoring treatment with antipsychotic medication. Is that this? So could you help me what's your position on that?
It's very confusing. And so the Rogers order did enter. Again, that was assented to. That was not the result of a contested trial or hearing either. And that entered, I believe, in May of 2017 or June of 2017 and expired a year later, because they always expire by their terms. Guardianship of weed and other cases, that MUPC 306A. And so if they expire by their terms, and the reason for that is, again, has to do with the current finding of capacity and substituted judgment. So it was not in effect, neither the finding of incapacity or the substituted judgment treatment order itself. It was a legal. It was by operation of law.
It doesn't seem to me, reading the judge's decision, that he relied on that as a base. I mean, he doesn't say that she's psychotic. He recognized she's off the Abilify, and she's taking the PTSD drug instead. So why does that affect why is the ultimate decision on in capacity? How does that affect that decision?
Yeah. And again, I didn't write the principal brief. I think that the argument was that if, to the extent that the judge believed that there was a continuing, ongoing finding that she lacked capacity to provide informed consent for medical decisions, that error, a mistake as to her capacity, was ongoing.
So then, let me just, the order that was given that includes that monitoring treatment, is that the same as, it doesn't say that she can, force treatment with antipsychotic drugs. It says she's supposed to monitor it. So is that a problem?
That is in the order?
Yeah.
Yes, because it doesn't exist, because the burden is on the guardian as the petitioner for the Rogers to seek to renew that each year.
But, does this actually give the guardian that type of authority? It says monitoring treatment. Is that the same as requiring her to take?
I think the concern is that two things. One is that may have influenced the judge, and also that at any point in time, any provider, if she goes into the hospital or she switches community providers or switches doctors, there's basically something on the books that it could believe a doctor, to think that the person can be ordered to take antipsychotic medication. So the role of the guardian was Rogers monitor, not that she can issue, force it or tell the provider, you must do this. That's the court's job.
A provider might read that order and say, oh, well, she's got the authority. She's monitoring, so there must be authority somewhere.
Yes, exactly.
I guess relatedly, I find it really hard to understand what this decree says. It says, control financial business-related affairs, but then says she does her own employment. Do you have a sense of how your client and the guardian are treating the guardian's control here? How they're interpreting this?
Are you asking me to go outside the record with what I understand, or?
Yeah, I guess so.
Okay. Well, I think it's continued to be, a very sort of contentious relationship, and I think that the order lacks clarity, and you're right, it was deemed to be granting her petition in part because it's deemed to somehow be more limited, a more tailored order, but it really just memorializes what she's already doing and then injects a lot of uncertainty, I think, into what the guardian's powers are. And I think if it was contentious and if my client was seeking her independence to begin with, that kind of order just adds fuel to the fire, if I may say.
You managed to answer that question without going outside the record. Any other? Your time is up, but we got your brief.
Thank you very much, Your Honor.
Morning, Your Honor. May it please the court, Catherine Kalo on behalf of the appellees, Josephine Kordahi and Nita Barber. At the outset, and without minimizing, I think, any of the liberty interests that come into play with any guardianship, I suggest to the court that this appeal is procedurally unnecessary, especially as it relates to the denial of the motion for new trial, in that even though we call decrees of guardianship, we refer to them often as permanent or final. That's a misnomer. They're subject to termination. They're subject to modification, and that continues. And that has continued since we tried this case in 2024 forward. It existed the right for SC to file the new petition to terminate at the time she chose instead to file her motion for a new trial. Had she done that, all of the safeguards, procedural requirements would have then been implicated. She would have her motion for funds for an expert. She would have been entitled to engage an expert and offer additional evidence as to her present capacity at that time or at any time. We could leave here today and SC could file the petition to terminate or modify the existing guardianship based on simply the passage of time. There's no requirement under the MUPC that certain benchmarks be met. It's just that she feels she can meet her burden again to modify or terminate.
Well, Counselor,
and that exists.
So, just because there's two ways to challenge a ruling, one of which gets a different judge involved and one where you have to go back to the same judge who you believe made a mistake, well, what does that matter?
Well, I just make the point because I think the prejudice with respect, and I know Your Honor raised that, the prejudice that, in my view, in the affidavits and the motion for new trial were not articulated. It's unclear to me, for instance, what an additional cross-examination of Dr. Sali relative to the cognitive results would have resulted in, when in fact Dr. Sali didn't challenge any of the test results. There was no offering, there was no re-administration by Dr. Sali of those results. And so those affidavits under the new trial fall short. What then? And in fact, that the guardianship was extended on the grounds of mental illness and not under the developmental disability or cognitive impairment that was alleged, that SC was alleged to have. So what is that prejudice? And then with respect to the accommodations, the SC makes a claim that when she left the courtroom for a period of time during the direct examination of the guardian, that her counsel should have asked for accommodations and that something was lost by virtue of her absence from that courtroom. At this point, we don't know what.
Okay, pardon me for interrupting, but can we go back to the original order, not the motion for new trial? What is the clinically diagnosed condition that results in SC being unable to make informed decisions on the areas that the judge found?
So based on the testimony...
And is it current?
Is it identified specifically in the decree? No, I can't say that. I can't say that's identified specifically. However, the evidence taken as a whole would establish that the past diagnoses and the diagnoses that SC has carried with her, which included mood disorder, anxiety, PTSD, bipolar, and borderline personality disorder. I understand she's only actively, at least as of the time of trial and by the testimony of Dr. Julian, was only being actively treated for depression. But Dr. Brown recognized, SC's own expert, that any one of those could be debilitating, that she only functions fairly independently. That was in his report. That was in the report that was filed with the petition to terminate. Then you had Dr. Brown and Dr. Sali both testify that borderline personality disorder doesn't get better. You had Dr. Gray disagree, but Dr. Brown and Dr. Sali both said Dr. Sali specifically said it's something you can't shake off. And then Dr. Sali and Dr. Gray both recognized the risk of decompensation. I think Dr. Sali saw a heightened risk of decompensation, but certain Dr. Gray acknowledged that. And Dr. Gray's testimony in part also seems to indicate that his support of the termination, at least in part, was based on the fact that he understood SC would continue to receive DDS services, that she would continue to receive services from LifeWorks and live in the supported housing. And then you had testimony
Is that from your client's point of view, the central focus of the guardianship is the maintenance of the existing housing and adjacent supports in light of the fact that there was a finding that SC was not amenable to those?
Yeah, it's the safety concern, and under the MUPC, it's the personal safety concern, SC's personal safety. That would be the guardian's primary concern.
Let me ask you this. I looked at Dr. Sully's testimony in his report pretty carefully, and I see place her at risk for financial exploitation, risk for decompensation, oversight would be beneficial, there should be oversight involved. What I don't see is any statement that she lacks the ability to meet the essential requirements for physical health, safety, or self-care. I mean, so how does this testimony get us to what you need for a guardian? I mean, everyone could use oversight, but how do we get there from that testimony?
I would suggest that on the safety piece in particular, Dr. Sali's testimony relative to SC splitting medical providers, but also if you look at the CTR that was admitted as an exhibit, it indicates that SC has convinced other residents not to take their medication, has made arrangements through online sales to meet strangers, has brought other residents with her, has engaged in a relationship and ultimately married a man she knew nothing about that assaulted her father and proved to have a propensity for violence. And this coming from a person who at her lowest was the victim of serious domestic violence. And so then you look at the credit cards and the poor judgment exercise, and that even if she vacillated, I think at one point between my mother gave me permission or maybe she denied altogether using them, but either way, I think Judge Phelan and Dr. Solly saw an issue with that she was getting permission from somebody she knew to have dementia. SC reported herself that to Dr. Solly that her mother had dementia. And of these things, I think, suggest that she's not capable. She's not capable of making decisions that would keep her safe and thus needs the supports that have been in place. And her testimony that she wants to move out and move in with her mother or leave LifeWorks and leave the supports of DDS create that heightened risk of decompensation. And that's where I think Dr. Solly's testimony really establishes that she cannot meet her own safety needs.
Do you have an explanation for the carryover, so to speak, of any aspect of the Rogers order that appears to be undisputed that it had expired by the time of the trial?
So I see a distinction with an important difference between being able to just monitor, having the authority and an underlying appointment to monitor antipsychotics, because if you look at the appointments, they typically say to monitor antipsychotics in accordance with treatment plan dated. We don't have a treatment plan. There's no active administration of antipsychotics. That wasn't disputed. There's no treatment plan signed by any physician now or at any time since 2018 when it expired that would allow the guardian to authorize any treatment. So to suggest that SC requires or doesn't have the capacity to monitor her own treatment, I think that's all it does. It recognizes that should there be a treatment plan, should the Rogers authority sought to be renewed, that would require a separate process. That would require the filing of the modification. Rogers counsel would be appointed under 5-306A. There would be a full hearing. There would need to be a clinician's affidavit establishing what is this treatment plan and all of those protections that come along with it.
Right, so why is that provision necessary where otherwise the judge left management of prescribed medications to SC in the decree?
Why is the provision?
I don't understand how that fits. I agree with what you're saying, that there would be a new process required, but you're not arguing that there was any substituted judgment trial held here, right?
No, the issue of substituted judgment, frankly, wasn't before him. And I acknowledge that. I think I acknowledged that in my brief, and I'll acknowledge it today. There was neither party was asking for anyone to determine and exercise substituted judgment.
But do you disagree that the findings suggest that at least in some parts of the findings, the judge seems to have either believed that there was something still in place or was operating under the understanding that the parties were carrying forward some aspect of that?
I don't think it's clear, but I don't think there was a misunderstanding. I think that there was clear testimony that SC is not being treated actively with antipsychotics. And
right, but
there
less
was
important than that, but there was no order in place.
Correct, there was no treatment
plan. She wasn't receiving treatment at that moment.
Correct. So in one step, to Your Honor's point, there was no order that would have authorized it. There was no active treatment plan. And I don't think that was an issue of confusion, that Judge Phelan was clear on that issue. Every expert, no one contested that issue. It was undisputed.
So what does it mean to monitor treatment? Like, what does that allow the guardian to do?
So typically on the clinician's affidavit and the ultimate treatment plan that's endorsed by the court, there might be a range of medications, so a range of dosage, and then the guardian with input from not only the incapacitated person but the treating clinician would have the ability to increase and decrease, again with the medical professional in the input, within that range. So that would be a monitoring for side effects, particularly given the nature and the drastic.
So let's be concrete. Let's say the ward and her doctor decide that she should start some antipsychotic medication and starts that. What would the guardian's role in monitoring that be?
Prior to a treatment plan being endorsed by the court, or
well,
after?
I don't see why there need to be a treatment plan if the ward and the doctor both agree that they want that. It says that she can make her own general medication decisions.
Except Judge Phelan excludes the treatment with the antipsychotic medication, which requires, I think, a heightened.
So are you telling me this decree prohibits the ward from voluntarily taking antipsychotic medications if she and her doctor think that's what they want to do?
I wouldn't suggest it prohibits her, but I would suggest that the better course would be that the doctor should, in consultation with the guardian, obtain the appropriate Rogers authority to ensure that SC has the capacity to understand the serious, often irreversible side effects of antipsychotic medication. That would be my concern, that she does not have the capacity to understand that.
So you would understand this of at least allowing your client to challenge the ward's decision to take antipsychotic medication, to litigate and say there should be a Rogers process before she starts taking the medication she wants?
I think that would be the guardian's prerogative, yes. I think that the guardian would file a petition to modify to include that. And I think given the issues raised with respect to SC's capacity, that should happen. That any treating physician shouldn't automatically assume she can consent to the treatment of antipsychotics. That's an extraordinary measure, not just an ordinary medical treatment plan. We hold it differently under the MUPC for that reason.
Yeah, it just seems like then this decree has a tremendous effect on her medical independence if she can't start medication she wants without litigation.
Well, she can, just not in the class of an antipsychotic or any other extraordinary measure that would require substituted judgment.
So I'm not that familiar with the Rogers case law. I know it requires court intervention before someone can be required. Can you do Rogers to stop someone from taking antipsychotic medication they want to?
It's an interesting issue. I don't know the answer to that.
I don't either.
Yeah.
I haven't studied it. I thought maybe you'd have some practitioner knowledge.
I would think that perhaps under a petition to modify the guardianship, because if the guardian or frankly any interested person was concerned that the incapacitated person or the ward couldn't understand or appreciate the side effects, perhaps that they're even experiencing, then it would be necessary to protect them. And then I would think there may be a duty on the guardian to bring that petition. But I've not seen that. Any other questions?
I just noticed at the end of the order, Judge Phelan recognizes and is grateful for the high quality of lawyering evident throughout the trial by both attorneys. It wasn't you yet, but I think that extends to you too. Thank you both for your arguments, and we'll take it under advisement.
Thank you very much.
All right, we have one more for now this afternoon. Department of Children and Families versus Mother, although they're all kind of on the same side. 25P102.
But you have to sit separately, just the way it is.
Give her a moment to sit down.
But that,
Give counsel a moment to sit down. Okay. Go ahead.
good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant mother, who, along with the other parties in this case, request remand to the trial court with instructions to the court to assert jurisdiction over this matter. What happened here in a nutshell is that the mother acted to secure her daughter's best interests by arranging for a private adoption. And then when that fell through, the trial court's extremely narrow view of its own jurisdiction meant she was completely cut out of the care and protection action involving her daughter. The court's interpretation of its own jurisdiction was erroneous and served no purpose other than to deprive the mother of the due process protections that parents are entitled to when the state intervenes in family life. This is a grave error that requires reversal and remand. The trial court's view of subject matter jurisdiction governed its decisions both on the question of whether the mother could revoke her adoption surrender and whether whether to approve the motion for post-adoption contact. The court actually had jurisdiction over them both.
Can I ask you, I want to make sure we're all on the same page here. When the statutory term is agreement for post-adoption contract, that's referred to colloquially as a open adoption agreement?
Exactly.
Okay. And what is just, how was the case left? So mother's not in the case, and so what is the status? How is the case left with the child now? Like, is the child in limbo, or the child's in DCF custody?
So at the conclusion of the matters, the child, so with regard to the mother and this child, in this particular matter, the mother's rights were considered to have been surrendered before the care and protection ever began, and the mother had no rights whatsoever over the child.
So the judge finds the child in need of care and protection without the mother.
Yes.
And orders what?
So what ended up happening is that there was ensuing litigation over the father's rights and the mother's rights with regard to the two older children and their father's rights. And at the end of the day, the mother signed open adoption agreements for the two older children who are...
What about what's going on with this child?
With this child, she is in foster care, a pre-adoptive home,
okay.
Or at least as of the end of the proceedings that are on the record, and she does not see her mother, and hasn't, because the mother was not allowed the typical visitation during the pendency of the care and protection action, but the older two siblings do. She was placed with her older sister.
But do you know what's happened with the care and protection case that you want to join?
So that action, to my knowledge, and perhaps counsel for DCF can correct me if I'm wrong on this, is essentially, it remains open until the children are adopted. But in terms of active, and until then, there'll be permanency reviews periodically until...
Has the father's rights been terminated?
The father's rights were terminated.
On appeal?
I do not believe those are on appeal.
I mean, I'm sorry to... Can the department advocate for the open adoption agreement without mother being there? Without the mother being recognized as a party?
Well, I think that...
I should ask them.
I think the answer is yes, because in an open adoption agreement, so an open adoption agreement typically involves the biological parent and the adoptive parent. And the adoptive parents are not parties to the care and protection, and yet they enter into the agreement, and then when the child is actually adopted, this is all subject to approval by the adoption judge, who reviews it and determines whether it remains in the best interests of the child. But I don't think there's any need for there to be for the mother to be a party for that agreement. And also, the court has equitable jurisdiction to grant post-termination, post-adoption contact between parties who are not biological parents. And so, for instance, adoption of Odetta, there was continuing contact ordered with an uncle. Continuing contact has been ordered with grandparents in these care and protection actions, because the focus in that proceeding, in that assessment, is the child's best interests and not, who's who. Who is it important for the child to see?
Right. Okay, I'm sorry to have diverted you. Let's get back to jurisdiction. There's no case holding that a juvenile court can hear a motion to revoke a consent that's executed under 210 Section 2, right? There are cases that say the probate court can do that. So what is your statutory path that gives the juvenile court jurisdiction?
Well, the juvenile court, and this is, I'm adopting the argument that's set forth in the DCF brief, which is that both the juvenile court and the probate court have jurisdiction over adoption proceedings. Juvenile court has jurisdiction when there's a pending care and protection action. The trial court, when it decided that the probate court and only the probate court could hear the mother's motion to revoke, was relying on cases that were decided, two cases that were decided in 1962 and 1935 respectively. And the statute that gave the juvenile court the jurisdiction to hear adoptions when there was a pending care and protection action was revised in 1992. So those cases, those two cases, really don't have any particular relevancy to this case. In those cases, the parent's motion to revoke was...
I understand that, but so tell me the statutory, how we get to, like, what statutory path, if I was to, do we explain to the judge that you have a jurisdiction?
Okay, so the 210, Section 1, says that the juvenile court can decide matters, including adoption, when it is necessary and convenient, as long as there is a pending care and protection.
Okay.
There was a pending care and protection in this action. The hang-up for the judge seemed to be that the mother signed the surrender before the pending care and protection action.
So the motion to revoke was after it was pending, right? I mean, she signed the surrender before, but then it was pending. And
but the motion to revoke was afterwards. Right. After she would have gone forward with the adoption surrender in the probate court if the sponsor of that adoption had not withdrawn.
So does that mean we send it back and tell the judge, exercise jurisdiction, or does that mean we send it back for the judge to determine whether exercising jurisdiction is either necessary or convenient, and let the judge figure out whether that's the case?
I would suggest that it should be sent back with the instruction that in these circumstances, it is necessary and convenient for the juvenile court to assert jurisdiction, because the juvenile court had jurisdiction over every aspect of the care and protection of this child from the time she was less than a month old. And so to say that we're just going to cut out this one little piece involving her mother because of the timing of when she signed the adoption surrender, there really doesn't seem to be any logic to that other than an extremely stingy and narrow reading of jurisdiction. And even if, you know, of course the statute doesn't say something along the lines of, and if the parents happens to sign a adoption surrender that would have gone forward in the probate court, but the care and protection is filed, it doesn't say anything like that, right? But even if this court is not entirely convinced by the statutory argument, certainly the judge had equitable authority to assert jurisdiction, because otherwise, equitable authority exists precisely for situations like this, when there is an injury, and here the mother's injury is of a constitutional dimension. Parents are entitled to the full array of due process protections when they are facing termination of their rights.
So usually this would come up in a non-DCF context when the probate judge is asked to approve an adoption and the parent who had surrendered would file, I want my surrender revoked.
Right.
Is there any way, in a non-DCF situation, for a parent to affirmatively file a declaratory action in probate court or something to vacate their surrender, or do they have to wait until someone tries to approve the adoption?
Well, I don't think they would ever do that because if no one was trying to adopt the child, I'm not sure they would file some sort of, and that goes to whether the mother truly had some sort of remedy in the probate court. I would say no.
Yeah, I mean, it sure does. But I mean, you can imagine a situation where someone like here turns over the child to Jewish Family Services and they're having trouble finding the right family to adopt, but the mother wants the child back now. What's the path? Again, if there's not a DCF case going on.
If it's not a DCF case, I would imagine that the parent could say, you know, for instance, if the adoption fell apart because the adoptive parents decided they couldn't take the child, and then the parent said, well, since this adoptive couple can't take the child, I'll take the child, right? I suppose the parent could just do nothing, right? But the parent could possibly bring a motion for some sort of declaratory judgment or on their adoption surrender. This case is different. I think if the mother had gone to the probate court and said, I want to void my adoption agreement or surrender, she didn't have a docket number. There was no case for her to file a motion into. And if she had gone to the probate court, I think the probate judge would have certainly said something like, you're telling me that the child is in the care and the protection of the Department of Children and Families, and there's a petition that the child's been added to, and everything about this child is being decided in the juvenile court. I don't see how I could or should be considering a motion to revoke
And
here.
what if she added, well, I have to because the juvenile court judge said this is the only place it can be adjudicated in?
I think in those circumstances, the probate court would still be disinclined, but certainly she shouldn't have to. She should not have to, a parent should not have to go through hoops like that in order just to invoke their constitutional rights. There's no question that a parent who signs a surrender, whether they sign it in a juvenile court action or a probate court action, has the right to file a motion to revoke that surrender. That is entitled to consideration on the merits. There's no question about that. Here, the juvenile court certainly had the equitable authority to consider that. And then further, down the road, even after it refused to consider that, it could have and should have used its authority, whether it be statutory or equitable, to decide upon approval of the agreed-upon motion of all three parties that would have provided for once-a-year contact between the child and the child and the mother. And in fact, the court had approved the same agreement, virtually the same agreement, with regard to the older two children. So it seems particularly striking that the court just threw up its hands and said, no, I don't have jurisdiction. I think that the court really was very hung up on the question that subject matter jurisdiction can't be waived and confused the question of standing with the question of subject matter jurisdiction, and they are related, and it is a little hard to untangle them, I would agree with that, but the cases that I cite in my brief, most significantly the Risonos case, show that when there's a considerable injury without a remedy, the court can take an expansive view of a matter of standing.
Do we have the open adoption agreement in the record?
I believe it is, but I would have to double check that.
Okay. And so we're talking about one visit per year?
Yes, that was what the...
Is there anything stopping the adoptive parents from allowing one visit per year?
No. They could do that. Once a parent becomes an adoptive parent, they can let the child see whoever they want to see.
We've got it at Record Appendix 90. Okay. Any more? Okay, thank you. We'll hear from the department. Oh, wait, actually, I'm sorry. Attorney Kaiser, I've got one more question for you. Please, I apologize. I apologize to everybody for confusing this. Don't run the clock. So the order, assume we agree with you, the order would be to remand the case to the juvenile court to act on the motion to revoke the consent, and then to act on, and if the judge agrees, if the judge finds that it was through coercion or not voluntary, then consider whether to accept the open adoption agreement.
So, Your Honor, I don't think that the judge would have to accept the revocation on the merits, right? It wouldn't have to go back and make a decision about that on the merits. What I would think would be the best order would be to instruct the trial court that it had jurisdiction over both the motion to revoke and the motion to approve the agreement, because then when it was remanded and the case went back before the court, I think the parties would be pursuing the question of the open adoption agreement. But just, as it is the typical way that these agreements are reached and are resolved is that the parent surrenders their rights, just like that step would be unnecessary.
So she gets her rights back to surrender them.
Yeah.
Yeah. Okay.
Thank you.
Thank you.
May it please the court, Claire Gilchrist for the Department of Children and Families. We're asking you to remand this case to intervene to achieve permanency for this child. This child is ready to be adopted, and this, but for this, the juvenile court's position on jurisdiction, could have been adopted, and so this is really delaying permanency at this point.
Why can't the child be adopted if there's a mother who has consented to adoption at this moment?
Because we're in appellate proceedings right now.
Oh, is that okay? Okay. So what would be? I'm starting at the end. The remand order would be what? To do what?
The remand order would be that the juvenile court has jurisdiction to rule on these matters raised by mother.
So I mean, there was a whole hearing on it, but then in the end, the judge said, "Okay, I'm not gonna reach the merits," right? So, rule on that hearing, and then the mother's, if the judge agrees that the mother that the surrender was invalid, then allow her to surrender. Then consider the adoption agreement next.
No.
No. Okay.
Not one then the other. Just that there's jurisdiction on both. And then the parties can pursue whatever seems best. So now, the parties are in agreement around this open adoption agreement. So I think that likely that the parties would just simply move the juvenile court to approve that agreement and not try and get some sort of ruling on the merits on the surrender.
It seems to me, correct me if I'm wrong, we have to rule on the jurisdiction to approve the open adoption agreement, period. We can't just rule on the jurisdiction of the first one, because then there's a danger the judge will say, okay, here's my findings, the surrender is fine, and therefore I can't approve the open. We have to reach that either way, right?
Correct. Yes.
And your suggestion, though, if we make it more open, you have jurisdiction, you guys could figure out what's the best course.
That's correct, because even though, in the pleadings, it seems clear that mother is on board with this open adoption agreement, who knows if she has a change of heart and decides, no, I want to fight to challenge my surrender. And then would we have to then come back to the appeals court for answer on what jurisdiction there?
Okay. So let's go back to the beginning then. So what is the what is the statutory path? Is it 210.1? Is that?
So it's reading 210.1 and 2 together, along with the SJC's instruction in adoption of Thomas. So section 210.1 is what gives the juvenile court jurisdiction when there's a pending proceeding to exercise its powers under section 2. And the adoption of Thomas, the Supreme Judicial Court said the power under section 2 there is a power under there to determine the validity of a surrender executed under section 2.
Right. So the judges hang up on when the surrender was signed. There's one statute that I found that actually seems to give that some credence. It's 209C3C. This is adjudicating parentage. And it says that it can be adjudicated in a care and protection manner as long as the probate matter and the care and protection are joined together, and that the action that the 11924, the care and protection, is initiated before the filing of a complaint for parentage under 209C.
So that's what that section says, Your Honor, but I would argue the opposite, that supports the argument that the legislature did not intend to have that narrow reading with 210 section 2. It clearly, has shown that it will act intentionally to do that with 209C, but it did not do so in Chapter 210. And both. Is there any?
That's good. Is there any rationale for that particular order in 209C? Like, why would it matter for parentage that when you file it? Just because once the probate court starts, you don't want them to stop?
It could be, yes, it could be for administrative reasons, ease of judicial process, having to transfer cases back and forth.
Okay. And then, of course, you've got 21859, general equity jurisdiction.
Correct, Your Honor. There is jurisdiction and equity.
Do you agree with my view that, putting aside the vast inconvenience of it, there's nothing keeping mother from filing something in probate court asking for a declaratory judgment that the surrender is invalid?
Yes, Your Honor, I do agree with your view.
At this point, that would be astonishingly inconvenient, but...
Yes, I think it would delay permanency, and that's really the lodestar of the juvenile court and what we're trying to do for children to achieve permanency. And that is why, we, in 1992, we amend the statute and just make it easier for the juvenile court to hear these and decide these matters. And where there's no explicit narrowing of the court's jurisdiction to hear them, it would seem that to be an error for the juvenile court to itself narrow its own jurisdiction.
So if there was not an ongoing care and protection, a mother could not file in the juvenile court a Thomas-type petition, right?
Correct. But, well, let me think that through. A surrender could underpin an adoption in the juvenile court, whether there would be a care and protection proceeding. There has to be a care and protection proceeding for the juvenile court to approve an adoption, but that could be underpinned by a.
If there's not ongoing care and protection proceeding, but the mother wants to get out of the adoption that she's agreed with, there's no problem with neglect or abuse. That would have to be in the probate court.
Correct. That's correct.
But then, and if that was pending, and then there was a care and protection, would the jurisdiction go back to the juvenile court, or would you have to wait for the probate court? I think we have to think all these things. I think we have to think all these things out if we're going to say something about that.
So the mother executed a surrender that she then wanted to challenge, and there was no CMP. She goes to probate.
Yeah.
But then something happens. The child is in need of petition is
Right,
filed.
I guess it has to be something's wrong with the adoptive parents, right? 'Cause-
Something wrong with the adoptive parents. So then at that point, the juvenile court would have a pending proceeding regarding that child, and mother, presumably could attempt to challenge her surrender then in the juvenile court. I don't know,
Maybe it'd be, I mean, you could ask the regional administrative justice, like, Judge, can you assign this case over there because this makes more sense?
that's a possibility.
It seems like a situation where the necessary and convenient determination could go the other way.
Yes,
I guess I'm trying to drill down on, even if necessary and convenient is obvious here, it's still a factor. It could be different in different cases, right?
that's correct, Your Honor. That's a discretionary piece. But here, the judge didn't even reach that. She just decided, I just have no jurisdiction to even consider whether it would be necessary or convenient to hear this. Okay. Hearing no further questions, I rest on my brief.
Okay, thank you.
Good morning, Your Honors. Sandra Ferrigno, and on behalf of the minor child. And we are supporting mother's position that the case be remanded to the juvenile court for further proceedings consistent with the determination that the juvenile court had the jurisdiction to hear both matters that mother has raised. And, Your Honor, to your question about the child being in DCF custody, she will remain in DCF custody until such time as the appeal is resolved and we are able to come to an agreement in the trial court. But she is ready for adoption, and she would be adopted, and she is in the home with her sister. Her sister has been adopted, and she would then remain in that home with that family.
And there is an open adoption agreement with the older children.
Yes.
Okay,
Correct.
interesting.
With the sister,
With the
at least.
middle child.
Yes.
Okay.
Correct. And with respect to the open adoption agreement, Chapter 210, Section 6C, governs the agreements for post-adoption contact. And 6CA authorizes prospective adoptive parents and a birth parent to enter into an agreement. It doesn't signify a party. It says a birth parent. It has the right to enter into an agreement. If certain parameters under 6CB are met, it has to be in the best interest of the child, it has to be entered into voluntarily and knowingly, and the terms have to be fair and reasonable. So child's argument is that all of those factors and parameters were met in this case, and that mother, being the birth parent, regardless of whether or not she had signed a surrender, had the ability to enter into that agreement with the adoptive parent and the child and the department at that time.
And under 6CA, wouldn't a judge have to make those findings?
Yes. Okay. Provided that those parameters are met, and the statute says that the court shall approve the agreement. So as long as the judge can find those three parameters are met, then the court must authorize that agreement.
And presumably, if we say there's jurisdiction, that's where this would go.
Well,
the court would have to make the determination under 6C.
Correct. That is correct, Your Honor, yes. And you also had a question, Your Honor, about whether or not the adoptive parents, if there's anything stopping the adoptive parents from providing that visit. There is nothing stopping them, but also the open adoption agreement provides some protections for both the adoptive parents and for mother that would be absent if they just chose to send the child with the other child during those visits.
Okay. That's all helpful. Thank you.
Okay. And we did discuss, and I don't want to belabor the point, but also the equity jurisdiction really covers the matters arising under the 119 and 210 statutes. And mother unquestionably fit into that category, aside from the statutory provisions under 210 sections 1 and 2 read together, for the judge to allow the motion, to hear those motions. So we would be asking that the court reverse the decisions and remand with instructions to adjudicate the merits of mother's motion to revoke the surrender and evaluate the open adoption agreement on the merits of that statute.
Okay.
I rest on my brief. Thank you, Your Honor.
Thank you all.
Thank you.
When I saw that it was an agreed upon case, I thought, oh, great, simple, but not simple, not simple. So thank you. The case is submitted, and that's it for today. I want to thank the court officers and the clerks. And we have could speak to that.
All right, so we're going to go out and we're going to take off our robes, and then we'll come back and talk to all the students who are here. So please, please stick around.
Okay.
All rise.
Got it.